કોના નામે છે ખ્યાલ નથી, હમણાં થોડી વાર પહેલા ચૂક્યું. મારે એક જ કામ છે. અમદાવાદ શું છે? વિક્રમની સામે page wise mentioned for report board serial number 1 to 4 and 5. Daily board serial number 1 to 11.
Serial number 10. The applicant is acquitted by the trial. Matter is in.
Item 3 and 4. Item number 3 and 4. In the inter-exam charge sheet has been filed. To my lord. But the only thing is my lords may say that my lord has the court has not gone into the merit of the matter. Three and 4.
12 to 21.
Serial number 17.
Serial number
17.
yes.
I may be permitted to withdraw the petition.
Learned advocate Mr. D.S. Satyasar, upon instruction from 6 permission to withdraw this petition. Permission is granted. Dispose of present.
22 to 36.
Lordship, matter at serial number 24 in Delhi Board. Learned advocate K.R. Koshti is appearing in the matter. He has filed his wakalatnama, but somehow his name is not reflected. Today he has filed a sick note and he is
Serial
leading
number?
the matter.
Serial number,
24.
let it be called out. I will not adjourn on the ground of offense.
Lordship, there is his sick note today.
Then let it be called out. He is appearing for respondents.
No, Lordship, he is appearing on behalf of the petitioner.
Let it be called out. We will consider.
Please.
It's a for direction.
Because here investigation are in possibly likely to conclude. The lordships can defer it by 2 weeks. The report may come because we have been called for statements on and off. Therefore, earlier also.
Serial number 35. Learned advocate Mr. Sharma. Praise for time. As investigation is likely conclude within 2 weeks. To release this matter on 28th of July. 2 weeks.
37 to 46.
My lord, serial number 42. Here the applicant is admitted by trial court.
42. Learned Nachari, you are saying so and so for the Nachari. Submits that during pendency of trial, the proceeding of the trial proceeding criminal case number 12662 of 2019. During this petition, so pendency of this proceeding of trial concluded. File up according matter is disposed as not pressed in view of the subsequent development.
This is 43 and 44. It is sick note of other thing.
Let it be followed out.
$47 to $57.
49. I'm withdrawing this petition because charge sheet is filed.
You got the
Yes, on behalf of Mr. Dhawan.
so and so on. We have got the 6 permission to withdraw. So charge sheet is filed during pendency of petition with a view to avail appropriate remedy are available under law. Granted permission, granted disposal as withdrawn.
53. With the consent of the other side, may I request for weeks accommodation.
Let it be called.
Please.
Let it be called.
Please.
58 to 67.
Number 63. There is a lot of Mr. Kindly click on next week.
They will not. જે તારીખ આવતી 2021.
4th August.
Bless.
68 to 79.
Lordship says in the 77. The applicant is required by the trial court, whereby the matters will have controls in it.
70.
Yeah, Mr. Ansari. The applicant has been acquitted from the trial court, and the matter.
And then advocate so and so for after the 77. Submits during pendency of petitions, the trial is concluded before the trial. Therefore, not pressing this petition as petition becoming practice. Disposal is not pressed.
80 to 90.
76 lordship in Delhi board. And along with that separately notified board serial number 19, there are arising two matters of the same matter. Mostly lordship in this charge sheet has already been filed. I have called for the inspection. If my lord may keep it on Tuesday, I'll make a precise statement and because pending this charge sheet is filed, that is what my instructions are.
Yes.
If my lord may kind enough to grant me at least time till Tuesday, I'll get with the precise instructions and place the account around the record.
Tuesday.
For July.
Serial number 76 and separately notified 90.
190.
Both are arising of the
80 to 90. 91 to 97. 98 to 107.
Group chair. 1070. 230. પછી પર કોર્ટમાં 40 થી 46 230 86 અને 103 બધી 230 માટે નોટિફાઈ કરાવી. યસ
112 to 114. 115 to 116.
Serial number 1. I'm mentioning on behalf of Mr. But I request to those priority.
out of question. Priority is out of
Getting for five.
then wait for your turn. If it is called out, subject to convenience.
That's it for other accused is already filed. Because of
Let it be called out. If, no priority, except group matters and matters where the consent question, no priority.
170 to
Serial number
120.
160, my lord. Concern costing matter, I'm requesting for priority.
160.
160.
How to be?
Okay, sir.
Let it be called.
123 to 133.
Serial number 127 and 128. Consent causing losses.
Consent question. 230.
May I mention? Serial number 126. There is a note of Mr. Shekhar.
It's Joe.
3rd August. 134 to 143. 144 to 154.
My lord, 144. We have instructions to appear in this matter, and the advocate for petitioner is retired and he will be permitted to file a report.
About that.
7th August. 155 to 156.
160, my lord. This is concern costing matter, I'm requesting
230.
to file. I'm obliged.
Parties are present.
Yes.
167 to 176. Separately notified one. Serial number 127.
Number 5.
Yes, it per court matter. There is per.
Yes.
Separate one.
Oh, I'm sorry.
That I will pass.
Separate board serial number 1. Yeah, request for next week, we have the parties and upload the honorable expedited to ascertain the status.
Ascertain. Now everything is available online. You cannot ascertain.
I've tried to contact the parties, I was not able to. Because
Then
we had the bars.
then Let it be called out at 3:30. Entire board will call out 3:30. Possibly all the matters.
8 to 17. 18 to 29. 30 to 39.
Serial number 30. Extending of the previously rescue recording, it takes the workaround on the request for.
Number 32, learned advocate. What is your
Silence this, sir.
Shailesh Desai? Praise time to file is Vakalatnama for risk for number 2. Adjourn to 8th August.
7th August.
Serial number 37 also. In this matter, Mrs. Shekhawat is appearing. Today there is a single session.
30,
37.
specially notified.
Yes, Coach.
Jigar Gadvi,
Separately noted.
separately notified board. Mr. The name is Jigar Gadvi, 37.
No, Lordship.
17,
Verify and mention.
40 to 48.
Serial number 40 to 46.
Yes.
That petitioner is already the applicant is already passed away, so matter become infructuous. So serial number 40 to 46 all matter can be disposed of as he was already expired. I am producing the death certificate.
Advocate Mr. Bunesh Upara producing death certificate of Pradyuman Singh,
Who is the
who is expired on
18th
18/4/2023. The death certificate issued by Municipal Corporation, Nagar Nigam, Lucknow. Nagar Nigam, Lucknow. The said death certificate is taken on record in first matter. First matter ka number लिखना होगा. In view of this, the present petition stands abated. Accordingly, disposal as abated. बाकी rest of the petition में भी same order. उसमें वो ये petition में certificate है साल की.
I oblige. I'm grateful to managers.
Why you are producing one copy in 7 petitions?
Lordship, that I will produce 7 copy within 10 minutes. Within 10 minutes, I will supply 7 copies. I will supply.
So
Please
supply.
Only have 2. I will supply within 10 minutes.
49 to 58. 59 to 68. 69 to 79. 80 to 86. 87 to 90. 91 to 101.
90. And 1 week is not possible. 2 weeks. 2 weeks or 3 weeks. Sir.
20.
May I mention? Serial number 37, we are for response.
So let it be first board. Let the board.
102 to 106. 107 to 118. 119 to 131. 132 to 141. 142 to 150.
Yes.
Serial number 37, we are for respondents.
Legal document.
What should we keep it after a week?
Upon MLB 37.
7th August.
May I request for circulation of one miscellaneous application for tomorrow, since the main matter is coming up tomorrow.
Tomorrow.
And I have produced on record sale agreements. If typed copy may please be dispensed.
Whatever is required, you have to.
I'm here.
Yes.
You're also requesting for circulation of one matter for the purpose of withdrawing, as the parties have already settled.
2:30.
So if your lordship will keep it tomorrow, we are.
Right. 2:30 is not possible. 2:30. If you are going to withdraw, what is the difficulty? 2:30.
One matter was,
Give the
circulation was granted for one matter for 2 day, my lords, but it has not come up on the board today. Please, my lords. I'm aware.
May I mention?
next date, short date.
Third July.
Raju, let him verify. Otherwise, he will give short date.
Serial number 56 in separately. noted.
Now, no mentioning in the book. If you want to withdraw,
No.
yes, follow out करो.
For court board, serial number 1, Mr. Prakash Pandya, run it with you, leave not.
Now. Yes, PP. What is the position here?
For court board,
It was heard on application and he asked for time to take it certain. You were not there, Madam Susan, at the last shooting.
He was here, I
He
think.
made submissions. My lords cannot incline, therefore, he need to take inside the matter to.
Even yesterday, the matter was listed once again. Anyway, there is when the matter is called out, it transpires that matter was heard on last occasion, and matter is kept for taking instruction by the learned advocate from his client. Today also, the leave note is filed by the learned advocate. In the interest of justice, matter is kept on as a last chance. 1st of July. Top of the world.
second, Natural Patel advocates, run it with you.
May request for pass for my lords. Mr. Dave
Right.
has taken the instruction, my lords. Yesterday, my lord has
Yes.
directed to verify whether the application for transfer is made before the lower. My lords may pass. Please. Please.
Number 3, Mr. Vicky Mehta, run it with you.
Yes, sir.
Here I am not having instructions to withdraw.
What is the matter?
Not if your lordship
Yes.
recollect that.
Committee is
Yes.
here. The present petition is filed for following phrase. The learned advocate. And the brief text of these lines. Heard learned advocate Mr. Vicky Mehta for the petition. Who is appearing for the Mr. Jaiswal for the Mr. Mehta has submitted that on earlier occasion the courts have directed respondent authority to look into matter and follow the judgment of Lalita Kumar. No FIR is filed. He has further submitted that where there is a specific allegation made against the concerned doctor, Dr. Tushar P. Shah, and his medical team and the anesthetist, as the patient who is a relative of the who is sister of the petitioner, sister of the petitioner, and received severe medical complication during her treatment, and the petitioner is repeatedly alleging that there is medical negligence, and due to that he has lost his sister. Patri.
Yeah, it was a stone.
He has further submitted that in the operation which is carried out performed for the removal of the stone, the entire complication anti-completion is occurred due to medical negligence. And he has further submitted that he is challenging it in the present petition. Essentially, the communication dated 2/9/2019 by which the it was informed by the concerned authority to the concerned police inspector San, that concerned authority, that means the RMO 2/9/19 as well as 3/9/2019, whereby the RMO has informed the police authority that there is specially constituted team of the doctors have examined the grievance made by the present petitioner thoroughly and had come to the conclusion that there was no medical negligence, and therefore, being aggrieved by that, he has preferred this petition by with a following prayers, following prayer. And therefore, he prays to allow this petition. For contra, Mr. Deswal has drawn my attention towards the opinion given by the specially constituted committee of the various doctors. Dr. Shrenik Shah, who is head of the department and professor urology department, Civil Hospital, Ahmedabad. The another is Dr. Shailesh Shah, head of the department and professor anesthesia, Civil Hospital, Ahmedabad, and Dr. Kamalesh Parve, head of the department and professor general medicine, Civil Hospital, Ahmedabad, who have opined after thorough after going through the necessary material and also examining the case in detail, that the PCNL, capital letter, PCNL surgery, which was performed by the concerned doctor, can be associated with complication like spinal injury, and above injuries can lead to dissection of vertebral artery, and some of these complications may require intensive care for further management, which is provided in this case, and therefore it was concluded that there was no medical negligence by the panel of the doctor. Pursuant to that, the police inspector has received the communication from the authority, and therefore the allegation made by the present petitioner is by and large satisfied by the scrutiny which is undertaken by the panel of the doctors, the special committee. Otherwise also, if there is no case made out against the present petitioner, made out by the present petitioner, which requires further investigation in the matter. He has also submitted that if the prayer made in the present petition is also found misconceived in view of the specific opinion given by the medical authority. And therefore, he prays that no case is made out to exercise powers by this court, either under special criminal, under 227 of 26/227 of the Constitution of India or section 482 of the criminal procedure. I have considered the rival submission made at the heart. I have also considered the earlier order passed by this court. This court has permitted the present petitioner to withdraw the present petition. And as per last order dated 7/8/2019, the petitioner is required to be the petition is withdrawn by the petitioner with permission to approach the appropriate competent court to take necessary measures under section 36, 154, 156, 3 and 200 or any other provision of criminal procedure which was not availed by the present petitioner. And on receipt of such communication, merely challenging that communication by asking further investigation by specially constituted committee is found highly unwarranted and unjustified. The courts are not meant for satisfying the personal grudges and grievances merely on apprehension and suspicion by ignoring the opinions given by the experts, like, and more particularly the team of the experts. In view of this, no valid ground or reasons made out by the petitioner to grant any relief. On the contrary, the filing of such petition amounts to taking disadvantage of the procedure of law by making such allegation with a view to take misplaced sympathy in the favor of the petition. With above, the petition is disposal. Please. As not entered. Please.
Number 4, Mr. Jhalak Pipalya, Mr. Vimal Pune, Mr. Vishal Atwani.
It is so fast forward only after a couple of matters.
Why fast?
Only
So for court matter, every time yesterday you have also mentioned pass over. If your counsel is so busy, then forget about it. What is matter about?
What's take up the group pertaining to partnership products?
Whether you have prepared the chart. So don't argue every individual matter. Just give the synopsis and.
I'm sorry, I only just prepared the chart, but as far as this matter, these matters are concerned. The only issue is with regard to that whether firm is joined as party or not. Here, admittedly, firm is not joined. There are judgments of our honorable court.
Those judgments. 2012 5 SCC.
Lordship.
2015 1 GLRL. The 3 judgments you are relying on this.
Yes. To substantiate the fact that if it is not joined, it is fatal as far as the case of the prosecution is concerned. And therefore, without even going into the merits of the case, this honorable court in 2 reported decisions have quashed the complaint. Now, please see the complaint. Page 19. Lordship,
so notice is issued 138 notice.
Yes, notice.
Where is that notice?
Page 31. Lordships are referring to 13523.
The first matter I'm having This 15360,
But that pertains to company. Lordship may just keep it aside for a while.
1353.
Yeah.
So these are pertains to.
The notices in these group of matters were sent by RPAD, not South, then by UPC. But as far as I am
Notice
concerned,
is sent to whom? Partnership and partners or only partners?
साहब ऊपर काय लख्યું નથી. It is only directly by RPAD. It is addressed. Yeah. 1352.
Why so many copies?
This was just for the સાહેબ એમને ફાઇલ કાઢો એટલે મેં બે કોપી અપાઈ ગઈ ભૂલથી.
Yes. This 13525 is pertains to
13523 pertains to partnership fund. One three five two four, 525, 526, and 527. 5 minutes.
yes.
Yes. That's page 31 is the notice.
Yes. Yes.
It is first given as such not addressed, but in the body of the notice, it mentions merit.
Yes. Milan Towers, Bhagidari Petina Bhagidar.
Bhagidar.
Yes.
Bhagidari paid in.
No
na
notice
Bhagidar.
is issued
Yes.
to partnership.
Yes. Now please turn to page 19, 19.
Yes.
There also, Thomas Dharma said, Milan Tires na Bhagidar, Bhagidari paid na Bhagidar. Form is not joined. But therefore, this is directly covered under section 141, the proviso which is there.
Read that.
Yes. Offenses by company. No, yes.
Yes.
Subsection 1 of the
Proviso. Read whatever you.
I'll read the whole section. It will make clear. No, I'm sorry. Subsection 1. If the person committing an offense under section 138 is a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offense was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offense. Provided further that where a person is nominated as director of the company by virtue of his holding any office or employment in the central government or state government or financial corporation owned and controlled by the central government or state government, as the case may be, he shall not be liable for prosecution under this chapter. Subsection 2. Notwithstanding anything contained in subsection 1, where an offense under this act has been committed by a company and it is proved that the offense has been committed with the consent and connivance of or is attributable to any neglect of part or neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Explanation. For the purpose of this section, A. Company means a body corporate and includes firm or other association of individuals. B, director in relation to firm means partner in the firm. Therefore, this is wholly covered. And those two judgments which I of our honorable court,
Use the paragraph.
Yes,
the
para
relevant
9.
paragraph. No need to read.
in
Yes.
2015 1 GLR para 9.
Yes.
And this very judgment is followed in the second one,
Para 9.
para 9 and para 10 in the next judgment, which is this is of course unreported criminal nuisance application 16297 of 2011.
Where is that?
Kirit Bhai Patel
Yes.
versus state of
Para 10.
Para 10, yes, para 10 onwards. And the judgment of full bench of Honorable Supreme Court is also relied in both this judgment. Therefore, I am not taking the Honorable Court to those decisions.
And what about this 2012 Anita Ada?
But
Para
that is the judgment. Yes, paragraph 39, 42, and 43.
So,
But this is the first judgment on this point. Therefore, this judgment is relied by our Honorable Court in those two decisions.
so these are pertains to
This
partnership.
pertains to partnership firm.
So that is partnership firm is not joined.
Partnership firm is not joined, but therefore
No notice is issued.
no notice is issued.
The 141 proviso.
Now, the explanation and the
So these are submission pertains to partnership firm.
partnership
What about the
company.
other matters?
But, yes.
Application for discharge is also filed.
No, it was, I have inquired from my client, it was filed at earlier point of time, then withdrawn.
Yes. Now,
15360.
yes. 360. Yes. And other 15364 and
Yes, I prepared the chart.
yes. These are pertains to
This
company.
pertains to company. I've written the name of the company.
Yes. Here, what is our situation?
Well, Lordship will find in the chart itself, if the Honorable Court can consider. Column number 4, date and check, Lordship Court. But this is of 3/3/2007. The petitioner on the last column, Lordship will find date of resignation as director, 18/1/2006. And for this, as I have provided Form 32 issued by the Registrar of Companies at page 89, which says that I was not a director. Number one, page 89. I had resigned on that particular day. Lordships are referring to 15360. Yes, page 89.
Yes. Ramanik Lal
Serial number
Advani.
4,
Yes.
Manoj Bhai.
Ramanik Lal
18
Advani.
2006 resigned.
Ramanik Lal Advani.
No, I'm sorry. Patel
Page,
Manoj Bhai.
page 99. Sorry.
18.
Which page?
18.
89. Yes, 89.
Serial number 4, Lordship will find the name of the petitioner.
Yes. Manoj Bhai.
Yes.
Yes.
And in column number 5, date of appointment or change 18/1/2006, and the remarks is resigned. After this, let's on page 95, Lordship will find Form 20B, which is usually filed by the public limited companies as well as the private limited companies for filing returns. In that also, my name is not provided as a director because this annual return is pertaining to year 2006, 2007, financial year 2006, 2007. There also, Lordship will find my name is not there. The name of the director starts from page 99. The other directors are already there. Those names are already there. And the transaction which is alleged in the complaint is of 2007. I had retired in January 2006. Therefore, as far as
No liability.
yes, my liability as far as this part is concerned is not there. And even in the complaint, if the honorable court can see, that there is no single averment to even remotely suggest that I am the director of the company. I am in charge of the affairs of the company, which is a mandatory requirement under.
You are Manoj Bhai Kuwadi.
Not sure.
અવારનવાર આમાં ટાયરોની ખરીદી કરતા આવ્યા.
But then as far as me being director of company and in day-to-day affairs of the company, that the Honorable Supreme Court as well as our Honorable Court has taken a strict view with regard to the liability to be assigned as liability which is to be assigned to the direct under 141 also. Those averments are required to be there in the company. And Lord, on page 19, Lordship will find the transaction took place 24/1/2007.
So which are the judgments you are now
Yes.
relying? 2019-17 SCC and
But
2015 one.
1917 SCC, but I'll come a bit later. This is the judgment. 2015 one SCC. but
There are
it was
29 to 31.
29 to, yes.
Yes.
But this talks about the mandatory requirement of the averment in the complaint. And Lords, when under 482, Lords, when this honorable court is shown some uncontrovertible material on record, which is even not today, after these many years also not controverted by the other side by filing any affidavit or any other document, Lord, the honorable court may accept that argument.
What about the second
Yes.
judgment?
This is 2019-17 SCC. But
Yes.
this was a case
Yes.
in which the Honorable Supreme Court took notice of the fact that initially the petitioner in that case had approached the Honorable High Court by saying that he was not a director. But then those material was not placed on record. The matter got dismissed. He again preferred an application before the Honorable High Court saying that now I am having Form 32, Form 20, etc. Please accept it, in which notice was issued. And Milord, the other side complainant preferred SLP before the Honorable Supreme Court, where in his SLP the whole complaint was passed.
Yes.
And Milord, one more fact, in that judgment 2019-17 SCC, Milord, the Honorable Supreme Court has also held that in such a case where backdate transactions are shown, or that averment with regard to post-dated check issued is also necessary. Those averments are also not there in the present case.
Yes. Anything more?
Not.
Yes. Yes. Mr. Radanpura. You are appearing in which group? So these are two set of
But in company, there are two sets. One is preferred by myself and
you are appearing where the
both are directors.
directors who have resigned prior to this transaction. Yes. જુદું રાખો ને આ એક ગ્રુપ છે ને આ એક ગ્રુપ આજે કન્ટિન્યુઅસ એટલે બીજું બીજા ગ્રુપ બાંધી દો જુદી અને સાઈડમાં રાખો પેલા હમણાં આવશે પેલા મૂકી ના દિયો મને જુદું ગ્રુપ કરી યસ
Please. CRMN 9125
9-5
9125.
આમની આપો 9-1 યાર આ બે પેલા મને ગ્રુપ કરી જુદી દોરીથી બાંધી દીધી. બે.
Please.
Yes. 9125. Yes.
9127.
Only one matter you are appealing.
Six group of matters, my lord. In the same petitioners are there. All are the accused, my lord. The petitioner number one.
Jalak paper.
The applicant.
You have not prepared any chart.
I'll prepare, but some mistakes I will provide within an hour, my lord. I'll
Then
provide
how
it.
I can appreciate your,
Because my clerk is
that
not
your matter may be detached from this.
within a half an hour.
You are not, the courts are not supposed to work as per your convenience. You are aware of, yesterday I have requested you to prepare the chart.
Prepared chart.
At least a minimum, this assistant from
I'll prepare.
where the
chart,
group
I will-
matters
I'll
are
get
there,
it, read
you
my
should
notes,
provide this chart.
I'll get it, my lords, but my clerk is not.
Yes, yes, what is the matter?
Please, my lord. The applicant number one, who is resigned from the company on 17/1/2006 from the ROC, my lord. ROC issued the certificate to the present.
Where is that?
Please, my lord, page 10. Type copy is on page 10A, my lord.
Page?
Page 10.
Yes. Yes,
Satish Kumar Rasiklal Patel. Petitioner number 3. This is from petitioner number 3. Thereafter, on next page, my lords. Page number 12. Petitioner number 1 name is reflected. Patel Anil Bhai Ramanikla, who is resigned on 18/1/2006, my lord. And thereafter, the last one is there, my lord.
so what do you want to submit from this?
From check was issued on 3/3/2007.
3-3?
Please,
3-3?
3/3/7.
Yes.
2007. And prior to the issuance of check, the present applicant was retired from the company. ROC.
So just like Mr.
Please,
Yes.
please, man.
So identical submission.
Please, man. Please.
Well,
Similar.
why you are wasting time then?
I am relying upon this judgment.
Additional.
In which, my lord, may
Oh.
read only head notes, 4 lines. Last 4 lines. So
Yes.
far as the companies are concerned, if any offense is committed by the every person who is director or employee of the company is not liable. Only such persons would be held liable if at the time when offense is committed, he was charged and was responsible to company for the conduct the business of company as well as company. I am not a day-to-day affairs because I am resigned from prior to 2007.
So government's in the complaint is not made
Not made.
to this. Yes. Yes, anything more?
Please.
So you are adopting argument, other arguments of
Please,
Mr.
other argument.
So you are similarly situated.
I am prior to the issue, I am not signatory of the check. That-
You have resigned prior to
Resign,
this or
resign,
not?
resign. Prior
That
to-
is your case
Please,
in every matter.
every matter.
Yes. I am give the your
Please, I will provide the charge
क्या आप so
within 15 minutes.
yes, yes, what is your
Well, it's in totality during the transaction, 12 checks were issued worth rupees 58 lakhs. In all the checks, signatory was Mr. Manoj Kumar, who is the client of People Asset Managers. Well, he has put his signature on the check as a director, in which the company was he was director, and as a partner of a partnership firm. Well, I may only show, my lords,
whether this fact is disputed by you that
well, it's the signature on the check, the date on the check, the amount on the check is not disputed by the accused, my lords. Nowhere in their application they have stated that this is not my signature, I have not issued the check, this is not the correct date, this is misused, or blank checks has been misused by the.
on the day submission is that on the given date they were not signed as a they were not working as a director.
was not privy to that information, my lords. I was shown that they
So
were.
checks are signed by the.
Please, my lord, the company na check છે અને એના ઉપર director તરીકે sign કરી છે સાહેબ. I may only draw my lord's attention to page number 35, my lords.
Yes. Opposite. Which matter you are arguing?
My lords, 15367.
1536. So you can argue one matter for the
Please, ma'am.
director and one matter for
Please,
the,
ma'am.
otherwise similar content.
And my lords, 13532. 23.
Ikadi Rani. Yes. First you argue this one five.
Please, my lords. My lords, before that, I may only show my lords, bring my lord's attention to page number 18, my lords. The complaint, my lords.
Yes.
My lords, એમાં સૌથી પ્રથમ Yogi High Tech Private Limited, that is the company I made the accused number 1, and thereafter 2 to 6 partner directors તરીકે, my lords. Now, let's accused number 2, Manoj Kumar R. Patel, he is signatory of the check, and એમની 153 ની series માટે a complaint petition has been lodged. For the remaining directors, my lords, Anil Kumar, Satish Kumar, and Kaneria Ramesh Bhai, my learned friend appears. He has preferred a separate petition. My lords, આના પછી રહ્યું ખાલી દિનેશભાઈ અને કંપની, my lords. Dineshbhai is not a signatory to the check, my lords. My lords, now it is their case that as on date when the check was issued, my lords, page number 35, check is there, my lords. Signature check ni date છે 3/3/2007, my lords. Signatory is Manoj Kumar as a director of Yogi High Tech Private Limited, my lords. He has issued check in the capacity of director, and thereafter the check was bounced, my lords. It is not their case that a particular director has misused the company's check. It is not their case that I have stolen that blank checks. Nowhere they have filed any complaint of this sort, my lords. Now they have come up with a case that, see, check is issued on 3/3/2007, but I resigned in 2006. Remaining directors resigned in 2006, my lords. I'm posing a question to myself, my lords. What remains in the trial thereafter, my lords? Nothing remains for me. My lords, company will now afterwards come with a case that, see, he was not a director at that point, and director of the company has not signed. Therefore, we are not liable. My lords, this will make my trial infructuous, my lords. There will be no point of that, my lords. Further, my lords, I have sent notice as per Negotiable Instrument Act. They have not replied to that notice, my lords. My lords, therefore, my lords, it is their attempt to misuse the procedure of law, misuse the provision, misguide this honorable court, and dupe the applicant, dupe the complainant, my lords. Therefore, my lords, the complaint may not be quashed, my lords. My lords,
Yes.
with respect to partnership firm, my lords, their main contention is that partnership firm ne accused તરીકે નતો જોડે, my lords. May only bring my lord's attention to page number.
What is your good name?
Abhishek Sharma.
Abhishek?
Sharma.
Yes.
My lords, in this also, check ma Manoj Kumar ni sign છે.
Which matter you are now arguing?
I'm sorry. 13523.
13.
Partnership firm na related.
Yes. 13523.
Please, my lords.
Yes.
In that also, my lords, page number 29. Check ma signatory Manoj Kumar છે for Milan Tires. ભાગીદારીના તરફે Manoj Kumare sign કરેલી છે. Again, in this also application, signature is not disputed, amount is not disputed, date is not disputed, my lords. My lords, thereafter, may I bring my lord's attention to page 68. Page 68. સાહેબ એ ભાગીદારી વિસર્જનનો દસ્તાવેજ છે, which is dated 30/3/2007, and I preferred a complaint in April 2007, my lords. My lords, it is that case that partnership firm was dissolved on 3/30/2007. My lords, if the partnership firm is dissolved, then why would I make a partnership firm as a accused in my complaint, my lords? I was not privy to this information also, but still, my lords, the purpose of making an entity as a accused was to that partners આવશે જશે, but entity and a person will remain there. So that entity or person should be liable to compensate to or proceed under 138 panels. Well, હવે partnership firm જ નથી, તો why should a technical
Where is check?
Please, my
Check in the present matter, copy of check. Where is copy of check?
please, my lords. Copy of check is at page number 29, my lords.
Issued by whom?
Issued by Shri Milan Tires, Manoj Kumar, my lords.
So partner.
Partner, my lords.
Yes.
Now they have brought up a case that partnership firm to dissolve થઈ ગઈ હતી. I was retired as partner also.
That is not the case.
My
They
lords,
are saying that you have not implemented a partnership firm as.
my lords, but how? My lords, I'm posing a question to myself. My lords,
How means
it is that
the check is issued by partnership firm.
my lords, the
for your
partnership
choice.
firm as on today or as on date of
That
filing
is,
of the
your
complaint was not a part,
interpretation.
was
Yes.
not an entity itself, my lords. કોઈ મરી ગયો હોય વ્યક્તિ એને કેવી રીતે હું પાર્ટનર તરીકે જોડું, એટલે અક્યુઝ તરીકે જોડું? The partnership firm dissolved, that means that it was terminated, died, my lords. So I
So
cannot,
read your notice,
please, my lords.
government's in your notice. Then why you mention Milan Tires Bhagidari Petina Bhagidar? Why you mention in your complaint, page 24?
My lords, because they issued
So
check on
you
behalf
are
of the
considering
partner.
them as a partner
Please, my
of
lords,
the
but
partnership.
I cannot,
Yes, yes,
make
you are right.
partner-
That is your interpretation.
Please, my
You are
lord.
right.
please, my lords.
માણસ
Let's-
મરી ગયો હોય એને તો ન જોડાય. You are right. Correct.
Please, my lords. That is my submission, my lords. My lords, in all, it is merely in connivance with each other, each directors, my lords. I was not shown that they have
Anything
resigned. us.
more you
No,
want to
no, please.
urge the advocates for the party?
My lords, only one
Dictation
submission, my
of
lords.
order.
Only one submission, my lords. The judgment they have cited will not be applicable because in all the cases, directors who have resigned were not the signatory of the check, my lords. That is
Here
my please,
there
my
is
lords.
difference.
Please, my lords.
They
The
also-
issue would be dealt.
First let him complete. Seniors જેવું તમને હવે એ ગોળાનું પાણી પીને એમાં થોડુંક આવી જાય. Yes.
Malad, the issue will have to be dealt with whether a director who has resigned and still was a signatory of the check will be proceeded under will be liable to be proceeded under 138 of please, my lords.
That's all.
Please, my lords.
Yes. What is your?
As far as that aspect of signature, the judgment will be on the court. 2019-17,
That which is relied by him?
no, related by
2019.
2019-17,
Yes.
SCC 294. In the case where I had mentioned that the facts were such that there it was a second
In the,
petition.
yes.
And when notice was issued, the other side approached the Honorable Supreme Court.
In a
That by-
their SLP. Yes, yes.
He was signatory. The Honorable Supreme Court in paragraph 3 has mentioned
Yes.
that
Yeah, otherwise
the
also
person-
on principle of every matter is not required to be seen from the
Right.
facts. So principle of law is sufficient. Yes, the matter is heard at length, heard Mr. Jalak Piparia in group of the matters for some of the petitioners, Mr. Rajanpura, Yogesh Ratanpara for the some of the petitioners, and Mr. Abhishek Sharma
Abhishek Sharma.
for Vimal Purohit, who is not present
My lords,
during the course of
And let's
hearing.
simply say Abhishek Sharma for Mr.
And learned, you are appearing in the entire group, Mr. Joshi. appearing. The matter is kept for dictation of judgment. The entire group is kept for dictation of judgment. छठी एक राखी है ना 10th. So arguments are concluded.
Grateful. We are okay.
So now no further argument, it will be. I will see that prior to that it can be dictated, but otherwise on 10th it will be.
We are grateful.
બધા ગ્રુપ વાઇઝ કરી નાખ્યું દોરી બાંધી જુદું રતન પરાની જુદી આમની બે જુદી કેવી રીતે
Number 5, Mr. MB Parikh. Mr. MB, आपकी रहेगा.
Yes. The learned advocate Mr. Parikh upon instruction from client seeks permission to withdraw with a view to avail appropriate remedy available under the law. Permission is granted. Dispose of as withdrawn.
Daily board. Serial number 1, Mr. Sunil Joshi, Mr. Kashyap Jani, narrative.
But I was cited as witness number 19 in the charge sheet filed initially. I was sub-registrar Kalol when the offense took place. The allegation against me is that my lords, I had received a document for registration which was executed by power of attorney holder, and the signature of the executor means donors are forged because they are residing in US. The power of attorney is executed in India. In my respectful submission, I am instrumental in seeing that offense is not further aggravated. I only admitted the document, it is presented to me, which I am bound to accept. Even if knowing that if somebody makes an application or objection that this power of attorney bears false signature under registration act scheme, I am bound to accept it. Then, my lords,
Which provision section 30?
32, 30, the entire scheme, I'll take the honorable court. Upon, my lord, receiving of the document, my lord, I postpone the registration. Page 93 may kindly be seen, my lords.
Yes.
Lords, 23/3 is the date of presentation of the document. Prior to presentation, there was an objection raised that I must state before my lords. And then, my lords, I wrote it to deputy collector.
Yes.
But this is my attempt to see that it is not registered. And on the last paragraph, page 94, last but the third, fourth line, I found that stamp duty is not properly paid. Page 94, my lords.
Yes.
And at the bottom, your lordships would find that વધુમાં નિવેદન કે સદરુ જમીન અંગે આપેલ પાવર ઓફ એટર્ની અંગે આ સાથે બીડાણ મુજબ બે વાંધા અરજી અત્રે મળેલ છે. જુદા જુદા
What
પાવર.
is present stage of trial?
Lords, the order passed by this honorable court where the lordships, the earlier bench directed trial court not to frame the charge. Order dated 26/2/2018.
So charge is not
Charge
paid.
is not. I am on the contrary, my lords. Please see my pate. I cooperated in the investigation. I saw to it that is not today. It is pending
Why then? Why the charge is not paid?
because, my lords, there is an order.
Yes, but why you have invited that order? If you have cooperated in the
I cooperated in
investigation,
the investigation.
what you will get?
No,
Charge is
no.
not paid.
Ultimately, what had happened that after the filing of charge sheet,
Why
I was-
you are afraid of trial.
I was called by the IO, which gave rise to an apprehension that I might be arrested. So I preferred anticipated bail before the district court. I was granted. Thereafter, they have filed a supplementary charge sheet against me. So I was a witness.
Proceed with the trial, whatever. So I don't think so, looking to the totality of the.
I would rather
I-
prefer to go for discharge. In that case.
It is also better option, better
Yes,
option.
Very good. I will do so. Because
Let-
there are two circumstances against me. There were phone calls between me and the,
That I have
But
seen
otherwise-
some of the papers I have seen.
yes,
So from that, I am not inclined
Very
otherwise. Learned
Because-
advocate, Mr.
but this
Joshi.
is the matter where
Up.
the property is then now subsequently transferred to others. Temple is built.
It happens. Unfortunately, nowadays, but we can't say that nobody is.
I understand. Looking to the position which he held,
Yes.
general impression which everybody would carry that.
Nowadays, it
Yes.
is very rampant. The learned advocate, Mr. Joshi, upon instruction from client, seeks permission to withdraw with a view to avail appropriate remedy available.
Specifically the discharge. Let it be.
Specific discharge application before the concerned court.
Yeah.
With a, it is open for the petitioner to avail that remedy in accordance with law. In view of this, petition is disposed of as withdrawn at this stage.
Well, obliged.
Mr. Jani. is
Number
for
two,
the
Mr. R.
respondent.
Gandhi.
Who is appearing? for-
Aye.
Yeah, Mr.
Here one of the petitioner is acquitted in trial. So matter will not serve.
Learned advocate Mr. Jani, upon instruction, submission of during the pendency of the trial, the proceeding of trial
Taken.
is concluded. Trial of sessions case number 134 of 2018 is concluded by judgment dated 30th January 2020 by 6 additional session judge court, Bhavnagar.
Lots.
In view of this, the present petition will become infectious and therefore he seeks permission to withdraw this petition.
Lots. Obliged.
Number 2, 3 and 4 disposed. Number 5, Mr. Sachin Vasauda, Mr. Samrat Mehta, Mr. Apurva Dave.
Yes,
Lord, now the law is settled by
copyright.
our High Court that the copyright, provision of Copyright and Trademark Act are not applicable to spare parts of the vehicle. Lord, the only, Lord, if we read the FIR, the only reproduction of the search and seizure of the spare parts of the vehicle is mentioned. That because of this, there is a infringement of section 63, 65 of Copyright Act and 103, 104 of Trademark Act. That's all. No other provisions are mentioned. Now, identical issue is already decided by our High Court in SCA 8903 2013. Same facts, same provision, same item. Our High Court says the Copyright Act is not applicable.
Yes, you are aware about this.
Prime officer, because already charge sheet has been already filed, lawsuit history has been granted of course. So far as the prime officer looking about the FIR lawsuit. There has been an infringement because the logo has been used of the particular company. The question is about the copyright as well as about the trademark, because the two sections have been added about the trademark also. And therefore, lawsuit, my humble respectful submission is there. That because already, yeah, it's a matter of the 2004.
matter. Very much in now.
No, mortgage, especially.
Special-
Especially mortgage.
So only humble submission is there because already Sri has been already granted. The judgment of my lord Justice Anand Khair was already there. I cannot comment about that one. But looking about that, it's not only for the copyright but for the trademark also lawsuit. The two sections have been already arised and charge sheet has been filed lawsuit. Therefore, it's a trial can be taken.
It is covered by judgment. What?
That shows about the copyright lawsuit.
No,
Copyright-
Trademark Act.
What's
Same
the-
Trademark Act is also. Trademark Act na provisions. Same.
103,
It's
104.
identical. So he is saying identical.
Identical.
Therefore, I am saying.
Page 7.
Yes, 103.
Exactly, same.
Yeah, just go. So if you want,
I'm aware about this.
You are-
So I cannot, obviously. Cannot overrule about that one. It's already squarely covered. There is no doubt about that. Yes.
એટલે marketing માં હતા ને,
All right.
allowed.
Lordship, immensely best.
वो बाद में शाम को निकाले.
Immensely best.
और ये same order वो देख ले,
Because this will be the one.
same order. ये वो चाहिए सबको. वो थोड़ा change करके fix.
This will become precedent, obviously. It's a number of cases are there in the market.
It's a legal position.
Legal,
It's a
right.
critical position. How I can prevent?
All right, Lordship.
Six, Mr. Jayaprakash Sumot, learned people.
Lordships, I may be permitted to appear, Lordship, on this behalf. Lords, this is a quashing petition. I'm squarely covered by an order of this honorable court, wherein it has been stated clearly that if the only evidence against the petitioner is the statement of the co-accused, then charge sheet also cannot be filed. My lords, on the last occasion, my lords, instructions were to be taken if there is any other evidence, because from the charge sheet itself, there is not an iota of evidence against me. I am not even named in the co-accused statement, my lords. The facts are this wise. That the original accused, who is the main accused, was caught with liquor worth some 58,000 rupees, lordships. That was in a rented property. Now that rented property was owned by my father. My father has now passed away, lordships. So in the FIR, my father was named as the owner of the property. I am not named. I am the son. Now in charge sheet, since my father has passed away, I am arraigned as an accused. In the entire charge sheet, there is nothing against me by the co-accused statement also to say that I am involved in the business. No, that is the
Where is that?
the judgment.
Co-accused judgment.
I will point out to my lords.
Thing. You have to point out that
Lordship,
statement of co-accused and
I will. If my lords may kindly have page number 43. This is an order dated 6/2/2017 in CRMA number
which
327.
software you are using?
Liquid text.
Yes.
Paragraph 2, lordships. According to the case of the prosecution, the liquor was seized from one of the co-accused, except the statement of the co-accused that, lordships, page number 44.
Yes.
Do I have my lords? Paragraph 2, my lords. I'm reading on page number 44. According to the case of the prosecution, the liquor was seized from one of the co-accused, except the statement of the co-accused there does not seem to any independent legal evidence to connect the applicant herein with the alleged offence. This aspect must be borne in mind by the police before proceeding further to file charge sheet. At the end of the investigation, if this is the only evidence to connect the applicant herein with the alleged offence, then the charge sheet cannot be filed. And if such charge sheet is filed, it will not take a minute for any court to quash the charge sheet. The position of law is that no charge sheet can be filed except on the basis of legal evidence. Then keeping in mind, this is the order I am relying upon, my lords. If I may take my lords to the FIR now. The typed copy is on page number 5. The FIR is dated 8/12/2017. In column number 7, my lords, where the accused are named. Number 1 is Chetan Hajarilal Urfe Rajubai Vacheta. If my lords may kindly focus on the address that is written. Shiv Park Society, Baba Bhai Urfe Ganga Bhai Rabarina Makan.
Yes.
Now, my lords, this Baba Bhai Urfe Ganga Bhai is my father, my late father. Accused number 2 is Wanted Hardik, who was assisting the main accused in the selling of liquor, my lords, as per the. And accused number 3, Makan Malik Baba Bhai Urfe Ganga Bhai Jetha. My lords may kindly note that I am not named as an accused in the entire FIR, lordships. If my lords may have column number 12.
Yes.
May I read, my lords? આ કામમાં હકીકત એવી છે કે ઉપર બતાવેલ તારીખ ટાઈમ જગ્યાએ કોલમ નંબર 7 માં જણાવેલ આરોપીઓએ ભાગીદારીના પોતાના અંગત ફાયદા સારું વગર પાસ પરમિટે ગેરકાયદેસર રીતે પરપ્રાંતીય બનાવટ ઇંગ્લિશ દારૂની બોટલ નંગ 126 કુલ કિંમત 100 તથા મોબાઈલ ફોન 100 ની રકમ આરોપી નંબર 1 મળી આવી તથા આરોપી નંબર 2
મળી ન આવેલ હોય તથા આરોપી નંબર 3 એ ઓરડાના સગવડ કરી આપેલ હોય. So my lords, the only role against me is that I have rented the property to accused number 1.
Yes. So I think I have also decided one matter.
When it is forming part of the statement of the board, matter may kind of principle. It is since the father expired, the son has given it to the accused number 1 and the accused number 2. Wherein Chetan Bhai and Apik. These are the two persons who are running this. No matter the act of giving the property or getting out the property and committing an illegal activity is always be the duty of the owner of the property to see that no such illegal activities. That may kindly be considered. And the charge sheet is the lead time. It's my lord, you kindly see the counter of the charge sheet, which is annexed along with the petition.
Page number 14, is the counter of the charge.
Now, my lord, 6th line. આરોપી નંબર 3 ના કબજા ભોગવટા વાળી ઓરડીમાં આરોપી નંબર 1 તથા આરોપી નંબર 2 ના ભાગીદારી પોતાના અંગત ફાયદા સાથે વગર પાસ પરમિટ ગેરકાયદેસર રીતે થર્ડ પાર્ટી બનાવટી ઇંગ્લિશ દારૂની બોટલો નામ 100 રૂપિયા 700 મોબાઈલ ફોન. Now, sir, today if I am posing a question to myself, if I am letting out a house to somebody, it is my responsibility to check that no such illegal activity is committed. If it is committed, if such illegal activity is committed, even I should be held responsible. And now, since the charge sheet is filed, it is at the stage of protest to appeal. Let the trial be. Sir, it is bound that it is going to be on the statement of the court in such circumstances. Kindly see the circumstances. It was the property which was let out that led to the circumstances.
Recovery is made from this premises.
From the house. And
The-
Wakar passed
Where is
the
this papers of charge sheet are with you?
No, it's his,
I want-
officer has gone to some.
230, let it be 230. Verify
Yes.
from where the recovery is made. If it is, this premise is connected to this, then I will not
My lords,
grant it.
my lords, even then, my lord, the
Whatever
only,
is the
only
legal
question
position, we have to decide the matter on facts of the each case.
I bow down to my lord, my lords, but
But some connecting material is available. why I
however, my
should
lords,
prove
it has
about the
been stated and it is amply
if
clear from
it
the
is
charge.
recovered from this premise, very premises or not.
My lords, it is recovered from accused number 1. That the papers of the charge sheet.
Whether this premises is
From this, I will fairly submit.
utilized for this purpose or not.
I have gone through the charge sheet
Verify.
papers, my lords. I will fairly submit that this has been recovered from accused number 1 from this premises, my lords. However, the question still remains whether the charge sheet has any iota of evidence apart from the co-accused statement. My lords, the order of this honorable court is
I
absolutely
am
clear.
not inclined. If that is so, then I am not inclined.
Page 17, manus from the bottom. 8th line. Chetan Sajjidan Urfe Rajubai. Achetia number so and so Shilbag Society Bababai Vesai Ragadina Matan. Govinda Isanpur, Ahmedabad, Sharma Harwani Janapur, Janati, Udrog Patni,
More than enough, Mr.
My
Why
lords,
you are afraid of a trial?
my lords,
Face the trial.
my lords, the yeah, in
Take
light,
instruction 230.
my lords, if I
You
may
can
just,
also call that
if I may just,
particular document.
if I may just tender, this is the death certificate of the. Of my
Other is a different thing, Mr.
He is the
You
original.
are occupier of the premises.
Lordships, I will seek instruction. Only in light of, my lords,
You
the
can't
order of this honorable.
take shelter of these technicalities. Where the glaring facts are there.
My lords, even
It
if
is
I may-
covered from their very
if I may-
premises,
My lord,
nothing can be done.
if I may be allowed, only 30 seconds. The order that I read before this honorable court, my lords, which I am relying upon, it has identical facts, lordships. That
Okay.
case is also pertaining to liquor, which has been found from accused number 1, my lords. However, it is clear, my lords, not if there is nothing in the charge sheet apart from the co-accused, my lords, the court has gone to the extent of saying that the police ought not to have even filed the charge sheet. The filing of charge sheet per se would be illegal in such a case. Well, I'll seek
If you
instruction.
want, I can decide that matter by taking different view also. Then,
I will
you are
seek-
aware that we have to decide matter
Lordship.
on facts of each case. Yes,
213.
take instruction from your end and you can also take instruction.
Obliged, Lordship.
7, Mr. Manish Shah, Ms. Bhavika Kotecha, learned PP.
Yes, please.
Here, the FIR for offense.
Who is expired? Number two
Number
is
one has
abated. Number two, that order is passed or not?
Number 2 has expired and order is passed. My Lordship have a previous order dated 6th of December 2022.
May I make one request Majesty, before it starts? There is one another matter arising out of same FIR that is also pending. My lords.
I'm not on it.
Another advocate has been filed, my lords, but
So for the same FIR,
same FIR.
quashing petition
Please, my lords.
for the same accused.
No, not same accused, another accused. My lord, other
But here is a case completely different. The builder says that I'm not willing, after entering into agreement, I'm not willing to sell the properties to them.
So you are ready or not today?
I'm ready. I have no objection. My lords. If we want to.
Let
let-
the matter maybe add together. So that is why we should invest in it. Give the number.
Give the number.
Any date after first, second week.
CRA 2659 of
2659.
2019.
I will give it
2659, you know.
in respondents. I am appearing in both matters.
SCRA
265.
CRN
26
2659.
26 CRMA or SCRA
SCR
2659 of 2019
19.
19 may be listed with along with this petition.
Great.
Second week,
Second.
third week,
And
third week, Rakman. After any date after 17,
17 August.
17.
obliged.
Please, Your Lordship. I'm ready.
17
Number 8, Mr. Ankit Shah, learned PP.
This matter, my lords, may I request for some time, Mr. Shah has some difficulty, my lords, medical urgency, he could not file seek note, my lords. Because on only Monday, my lords, if it appeals to my lords. He has some,
time and again the matter is adjourned.
please, my lords, but today, my lords, there is some.
There is no notice issued. No, in second call I will dismiss for want of prosecution.
But my lords, may I,
Irrespective of the presence of.
then my lords, in that case, may I request for Friday, my lords,
No Friday.
Friday, my lords, top of the board. If it
You
appeals-
take instruction and proceed with the
First,
matter.
I am not having the file, otherwise, my lords, I
You
would have.
go through these papers. No adjournment on this.
Please,
Don't ask for time in at least first 25 matters.
my lords, there is some difficulty,
Real-
genuine difficulty, that is,
Then the court is having more difficulty.
Please. please, my lords, obliged.
Number 9, Mr. Tushar Chaudhary, Cipro. Can dispose of 11, Mr. RB Thakur, learned PP.
Yes, PP. What is the present position? Report is asked for on last occasion. Court has asked you whether involvement of present applicant in the alleged offense. I don't know why court has directed you, but otherwise you applied all the possible section in one FIR. જગ્યા હજી વધારે હોત તો હજી બીજા એકાદ બે એક્ટ લખીને કાઢ. Read this. IPC, Prohibition Act, Motor Vehicle Act. So how the present petitioner is involved?
He was there.
Badarsi is
Page number 10, somewhere in the middle.
Badarsi,
Yes. Babarsi?
Badarsi, Nancy, Kuvarsi, Vagela.
Yes.
Here the Babarsi, Chelsea, Vagela. So person is different.
It's Badarsi. Badarsi?
Here you have said Badarsi. In petition, his name is Babarsi,
Sometimes.
Chelsea, Vagela. No. Even name of father is also different. Badarsi, Nancy, Kuvarsi Wagela.
Barasi Nancy mostly, Barasi Nancy Magela.
Anyway, he is not here. Let it be 2:30. Papers are with you. IO is here.
IU is not present.
2:30.
Number 12, Mr. A. Timbalia, Mr. Pradesh Kumar Waghela.
Password.
30, Mr. Maulik Seth, Learned PP.
Password.
14, Mr. Mehul Surti, Learned PP.
Password. Please draw my attention if wherever the IO is
Yes.
or any report that if a charge sheet is
40 minutes post the matter charge sheet has been filed. He also present.
12 and 40 charge sheet. Okay, second code.
15, Mr. Shivam Choksi, Learned PP. 16, Mr. Anik Kadri, Mr. Vishnu Bhandari, Mr. Parimal.
Yes. Password.
Dispose 18, Mr. Tejas Sattal, Learned PP.
Yes.
May I request to withdraw this matter upon instructions?
Learned advocate so and so forth. They just upon instruction 6 permission to withdraw. Permission is granted. Petition is disproved.
And your lordship may your lordship mention in the order with a liberty to file.
With a view to file appropriate proceeding before the.
Please, your lordship, much obliged.
19, Mr. Hardik Dave, Learned PP.
Yes, Mr.
Who accused matter? This order is it was filed on the basis of settlement, but now complainant is not agreeable. Therefore, some accused I had withdrawn last occasion. These are the remaining accused.
The same
order.
analogy.
Yes. Previous matter, in fact, matter of Mr. Satta was cross FIR. We all have filed together, but somehow it failed at present.
Same order. Please withdraw.
20, Mr. Pawan Barot, Learned PP.
The status we have given. Order is not approved.
Serial number 20. Learned advocate. When the matter is called out, learned advocate for petitioner is not present. Learned APP, Mr. Joshi. You are AP, Mr. Joshi. Submitted the status of the criminal case number 266 of 2022. And which was decided by second additional civil judge and JMHC. Which court? But which place? Surendran, which is taken on record, which indicates that the matter is trial is disposed of by passing by order judgment dated 31/3/2022, whereby the accused were acquitted. Considering the same, the present petition is disposed of as prayers in the present petition becoming infectious.
21, Mr. Dharmesh Patel.
No, this is for the direction to the police to not to dispossess me without due process of law or any order of the court. That is a
simple direction. Since 5 years, the matter is pending.
I'm sorry.
Since last 5 years, the matter is pending
Yes, my lord.
for simple direction.
Because my lord,
Why?
even the notice was issued. Thereafter, my lord, police has stopped harassing me. Otherwise, my lord, they are coming to my place and says you vacate this place. My lord.
Why? Police
There is
has no
nothing-
business to say so. Why police is saying so?
That is why.
What is your
Lord, it's a-
allegation? Where is your prayer?
Prayer. Page 8, my lord.
Yes, why police is harassing the,
On a similar matter was there day before yesterday. I inquired what happened in India also, there was some complaint was lodged. As a process, my lords, they inquire about the aspect. By this time, it is a 2018 matter. After 3 months, 4 months, all PI generally changed. Here also that there was my
it is a different thing, but why it was happened?
because
It
of
should
the
not be happening.
Thara book, my lord, let me tell you.
એમને જઈને puzzle, I can understand. Complaint is that then he should be arrested. Why they are asking to vacate their premises?
But that is there.
That is not business of the police.
But police have not asked. The panchayat have asked them, but now they have been.
No, your panchayat has also not asked. That is wrong, my lord. There is no complaint before the police, my lord.
I have 10A, I'm reading 10A. Janjak Pundi Karwana. Kharab.
So now, in view of by passage of time, nothing will happen. In case of difficulty, you can
My
approach
lord,
once
make
again.
statement that the police will not, my lord, dispossess me without due process.
That is goes without saying. I will direct them
Very, very well, my lord.
not to dispossess you without due process of law. And otherwise also, it's not business of police.
Police have no powers, my lord.
Yes, it is a.
Why
even after
police is
notice, they
entering
stop
to,
by harassing me.
unless there is direction of the court to give the assistance. And that is also for purpose of law and order, not beyond that. The present petition is filed for following prayers. Petition is filed in the year 2018. By passage of time, it transpires that now things which are apprehended by the present petitioner will not remain as it was, considering the fact that otherwise also the police officers without order from the any competent court has no power to interfere with the possession of the parties. And if it is required to be done, it should be done by following due procedure of law.
Just for a moment, just for a moment. These are persons who have encroached the panchayat land. There is an order of the state government, again, seem to vacate that encroachment made in the panchayat land. For example, if any authority asks for police protection has to be given.
Police protection is different thing. Then also police has no authority to vacate. They have forced them to vacate the premises.
Or right to convey to the police authority. Yeah, what happened? On one hand, he doesn't want to vacate that encroachment.
That my letter friend may show that the panchayat has ordered me to vacate, my lord. There is a. Yes, yes, my lord. My lord, I kindly see that.
પેલા લખ્યું ને કે it is
My letter friend
also
may file affidavit that I am there.
disputed by learned APP that the police is acting in high unlawful manner, and it is further submitted by learned APP that in fact present petitioners have encroached the land in question, and therefore the present petition is filed with making incorrect allegation. પછી આપણું in view of this, if requires, police will follow the necessary procedure in accordance with law to assist the concerned authority in case of the any order or direction issued by the any authority or any competent court.
Please,
With above observation petition is dismissed.
my lord, liberty may be reserved. If
That is always there.
without due process, my lord,
Without due process, then you can file appropriate amendments.
that is for that.
Why I
purpose-
should mention it. You also, you should also know that if you are not having any title
Because
over
my
the
learned
property,
friend is
then
saying-
you should not say
No, my
that.
lord, that resolution of the panchayatis has been set aside, my lord, may kindly say.
For my lord, this is giving.
Yeah, and my
Right-
learned friend
right,
is saying,
sir.
I'm the- if I am the encourager, my lord, panchayat will let
I'm saying.
I am not expressing anything on
third
merits. so
person, my lord, go.
I am just recording his submission, your submission, and then dispose
Very well.
by passage of time.
Please, my lord, much. May I pray for direct service?
For what purpose?
Sir, otherwise, I, Jew Sahib, I withdraw, sir.
That petition is disposed of in accordance in above with above observation. Direct service.
Much of it.
22, Mr. Arpit Patel, signal. 23, Mr. Chetan Pandya, 100 rupees.
Lord, I'm requesting for password as Mr. Pandya is.
For what?
Mr. Pandya is.
Opposite. Also.
24, Mr. Vishal Dave, Mr. Nipun Singhi.
Mentioned this matter in the morning. Learned advocate K.R. Pushti is appearing in the matter. He is on a sick note today. I am praying for tomorrow, your lordship. It's 1 day accommodation.
Why his name is not
Lordship,
repeated?
we have already filed his VP, but somehow I'll personally today go and check with the registry also about this. Your lordship. I'll
What
personally
is
go.
matter about? What is
Lordship,
matter about?
Endorsement says it is with regard to filing registration.
How
of-
the such petition can be entertained by this petition? File a PIL.
Lordship, Mr. Pushti will
But
assist this
Kosti,
honorable court on this.
whoever is, why I should enter into this?
My lordship may at least accommodate tomorrow. 1 day accommodation.
Illegal payment of train agency, why I should examine this?
I
Go and made a
I would pray just.
file
for-
appropriate petition before this. PIL,
Lordship,
Satya is
I'm grateful.
August, 27 August.
My lords are keeping in 27.
27 August.
I'm grateful.
25, Mr. A.R. Kadri, 100 rupees.
Opposite. Disposal. Learned Advocate Mr. Kadri submits that during the pendency of this petition, the trial proceeding, so and so on.
The stage of further
Concluded.
statement. At the stage of FS, further statement. Matter is.
The trial is proceeded further and it's a stage of further statement. Therefore, he is not pressing this petition. If disposal.
26, Miss Mamta Vyas, 100 rupees.
Concluded, nothing. Proceed.
Mr. Ankit Sar, 100 rupees.
Requesting for password. 2:30, I'll call for the paper solution. I'll proceed.
Both the matters,
Please.
earlier and this.
Please.
Otherwise,
Both the matters I will proceed.
yes.
28, Mr. Manoj Trimade, Mr. Vachal Pansala, 100 rupees.
Yes.
Last time your lordship passed the order to the order. Remain concerned officer at Sachin police station about this incident, my lord.
Yes. The Talwar
Yes, ma'am.
sword.
Yes,
Relays Varanpariya.
yes, my lord. That, my lord, I made a concern allegation in the, my lord, the FIR as well as, my lord, before the commissioner, concerned court also, my lord.
Yes, report. Who is Ayub? કેમ ભાઈ અમને પકડતા નથી તમે તલવાર આમનો ફોટોગ્રાફ છે પેજ 61 બતાવો ને 61. 62.
With regards to this, with my lord's may permit, I may order my officer. This is with regards to an offense in Cambridge police station under 302. The FIR is registered. Now kindly see the report. As far as the other aspect is concerned, one more offense was committed in the jail. And in the jail, my lords, against the constable. Jail Havaldar, there was some scuffle between them. And against the Havaldar himself, there is an FIR lodged. Kindly see the report.
So Pasada.
Yes.
So now
Milord,
they have taken instead.
But here, Milord, what,
necessary.
kindly, Milord, I will. My friends, even said nothing is being done, but FIR is right.
No.
But here only, Milord, I'm reading some lines, Milord, in the Milord, the FIR. પશાદાદા as well as કે નિલેશ ના વિરુદ્ધ જુબાની આપીશ તો પૂરું થઈ જાય કારણ કે 10-12 માણસો અંદર આ જેલમાં છે. This is the allegation, my lord. Since 2019 incident, my lord, પશાદાદા's file also, my lord, against this complaint file quashing petition, nothing else, my lord, till today. I made so many repair commissioner as well as, my lord, concerned court also, my lord. And Pashadada only given, my lord, one increment without future repair. That is the simple punishment given by the commissioner, my lord, as per my complaint. Kindly see, my lord. That order also I have annexed, my lord.
તમારે શું
Page
હું તમને
49.
હવે બતાવી દઉં છું એમ કે શું
No,
કેમ
this
નોકરી
is-
કરો છો એવું?
I have it.
Yeah.
સાહેબ એમને જેલમાં બેરેકમાંથી બહાર લાવી.
How the authority has to proceed, it's a discretion of the authority.
My lord, this
You can't compel the authority
But here, my lord, what,
to act in
but
particular.
what my submission is, my lord, not.
You are having limited right, Mr.
Yes, my lord, I understand, my lord, but what my submission is, my lord, not
In view
only
of this report,
not only against this present petitioner, my
what
lord,
you want? I am satisfied that nothing.
but only only one.
Now nothing beyond the
Only-
ego issue.
I understand, my lord, but my submission not only with this present petitioner, my lord. There are other 10 persons, my lord.
They
This
will
I have
have
annexed
that,
all
do need
the
to-
details, my lord.
The police is
It's a land
for
grabber.
that, and if they are not acting in a proper manner, it is not proper. But at the same point of time, you are having also your
No,
limit.
my lord, that is earlier, my lord, 2016, because of this some dispute about the, my lord, plot. Only my submission, my lord, there is some dispute because as per the partnership, my lord, he purchased me some plots, my lord, and on that basis, my lord, this incident occurred. Cross complaint file, where, my lord, I am the one of the, my lord, witness. There are other Mahesh Mungalpura and Dobaria. There are 3 persons, my lord. And on that basis, I am one of the witness at this incident of this as per the sword, my lord. Emma Sahib, he is under some other incident. He is in jail for 3 days. He is remaining there, and as and when he released on the bail, he immediately make complaint to the concerned commissioner, concerned police officer at the in the jail, and thereafter the court, my lord. But till 2019 to 2023, my lord, nothing happened against the Nilesh Vanpare, and not only my complaint, my lord,
He's
other
saying
10
that
persons, my lord.
there is a FIR.
My allegation is, my lord, not only Pashada.
Nilesh Vanparia.
As per the Nilesh Vanparia
Pertains to
instruction,
this
my lord.
very incident,
Yes.
complaint is lodged against the Nilesh Vanparia.
No, man, in this case, Nilesh Vanparia ne nathi sahib arrest karo. Only Pashadada is take action, my
This,
lord.
Talwar is with whom?
Nilesh Vanparia.
Yes, he pursuant to this case is registered.
Kindly see the second page.
You are not aware about the development.
But, my lord, when I have filed petition, first time he is coming with the report, my lord. Not only I am going before this court, I am going before the commissioner, concerned court, everywhere, my lord. તારું કશું નહીં થાય 10 લોકો આવા છે કે અમારા જેલમાં, not only પશાદાદા.
Yes. Yes.
On my lord's direction, my advocacy, this report is placed on record. I may read them. આ કામમાં
Nilesh Narayan. So this is I am giving on the first page, not the last page. I will so and so society માં બ્લોક નંબર so and so દસ્તાવેજ કરેલું એની ફરિયાદ પર પૈસા આપવાના છગા હતા તે પૈસા ચેકથી ચૂકવી દીધા એ પ્લોટની કિંમતને જે ચેક અને ખાતું જે ચેક આપે so and so રૂપિયા બાકી બીજા ચેક તેમની ધંધા ભાગીદાર મહેશ ગાંધી સુધારી SBI બેંકને 2 ચેક આપે તેમ ભાગીદાર બીટીભાઈ નામના HDFC બેંકમાં 2 ચેક આપે ये चेक ये चेक निलेश नारायण दत्ताએ સ્વીકારેલું છે અને પણ તે તેમના ખાતામાં નથી કરાવ્યું ખાતામાં જમા નથી કરી બરાબર જે પ્લોટ 20 નંબર 22 ના નામ નંબર છે તથા નંબર 94 95 નંબર अधिकारी महेश रविभाई सुतारिया तथा 86 87 માં નિગમના જે બ્લોકની માહિતીના આધારિત તેને નારાજગી દર્શાવે તે બાબતે નિર્દેશની પ્રક્રિયા તથા તેમના સાથેના આરોપીઓ ફરિયાદી શાંતિ કોશિશ કરી તેમજ જાનથી મારી નાખવાની ધમકી આપી ગાળો આપતા ફરિયાદી અરજદાર મિત્ર પરેશ છગનભાઈ તેમના વિરુદ્ધ ફરિયાદ આપતા જે કામરેજ પોલીસ સ્ટેશન ગુના નંબર 267 ઓફ 2018 આઈપીસી કલમ 307 325 323 વગેરે થી 22/9/2018 ના રોજ ફરિયાદ રજીસ્ટર થયેલ છે તેમજ આ બનાવમાં ફરિયાદી અરજદાર અને તેના ફરિયાદી વિરુદ્ધના નિર્દેશ પ્રક્રિયા મળવાની ફરિયાદ કરતી જે કામરેજ પોલીસ સ્ટેશનનો ગતો 2018
I am not denying, my lord. Only, my lord, when this Pasha Dada, as per my complaint, came before this, what is the, my lord,
2018 the case is the register.
but what is the level of the police, my lord? When the, my lord, this, as per this present complaint, when I want to see, my lord, that the not only Pasha Dada, but as per the Nilesh Vanpadia, Pasha Dada's file, my lord, this Purushottam filed quashing petition before this honorable court, that page 50, kindly see, my lord. In this court also, this honorable court observed that Sachin police not remain present with the investigation, my lord. At that time also, my lord. Not only today, my lord. 22nd February 2020. So, my lord, indirectly they are helping because he is the police officer. He is a havaldar in the jail, my lord. I am not denying that 267 Kamraj police station FIR lodged, my lord. But here, my lord, as per this, in that incident where I filed the complaint, my lord, this is the one of the witness, Mahesh Sutaria, present petitioner. And that's why, my lord, he is beaten in the custody, my lord. And says Nilesh Vanpadiaનું નામ લેતા કે સાક્ષી ના બનતું. That's why I came, my lord, before this one. But not only Purushottam Dai is only accusing this matter, my lord. And not only, my lord, against my lord, these persons were my complaint. More than 10 people that I have annexed all these, my lord, documents and FIR with this petition, my lord. Page 68 to 95. Several people, my lord, because he is a land grabber, he is, my lord, the one of the builders and giving the, my lord, the plots to the other persons and then cheated with the various people. Not only his brother and his wife also involved. This as per the 66 page, my lord, this one of the lady, she is a wife, my lord, of this Nilesh Vanpadia. Page 64, kindly see. Nilesh Vanpadia talwar mai sahita and wife broke case and said.
He is from Sachin police station. So what happened to 559 of 2019? Read his prayer in the petition. There is no whisper about the same in this report.
Can you see the first line? After special criminal application number 3252 of 21, the petition દાખલ કરે છે જેમાં હકીકત એવી છે કે પતિ પોલીસ સ્ટેશનમાં ગુનો દાખલ થઈને 2019 IPC કલમ 323 504 મુજબના કામે ફરિયાદી શ્રી મહેશભાઈ સંજીવભાઈ સુત્રાભાઈ ભગાતી શું છે.
Now he is arrested, Pasapa Dada.
Sir, now since my friend has made so many submissions, let me, my lord may permit me to read my report between first. Now, sir, I stopped at 22/9/2000.
Yes.
ના રોજ ફરિયાદ રજીસ્ટર થયેલ છે. આમ બંને પક્ષકારોને એકબીજાના વિરુદ્ધમાં ગુનાઓ રજીસ્ટર થયેલ છે. બંને ગુનામાં તેમની ધરપકડ થતા જે પૈકી આરોપી નિલેશભાઈ અને ઉતના લો જે પૈકી આરોપી નિલેશભાઈ નારાયણભાઈ વણપારિયા અને તેમની સાથેના અન્ય નાઓ 22/9/2018 ના રોજ રાજકોટ મધ્યસ્થ જેલમાં દાખલ થયેલ હતા અને 4/12/2018 ના રોજ જામીન મુક્ત થવા પામેલ હતા. Then my friend refers to there is some animosity with regards to the land transaction. When my friend says that 12 persons have been there, their names kindly see. તે પછી મેપલ જુદાના 12 પ્લોટ અસલ દસ્તાવેજો નિલેશભાઈ નારાયણભાઈ વણકરિયા નાઓ પાસે હોવાનું તથા પ્લોટોનો કબજો તેની પાસે છે એવું આરોપી. Now I am not wasting the honorable court time by reading the entire paragraph. There my lords may kindly see civil court માં ABF number 13/2018 થી દાખલ કરી ગુનો કરતા અરજદાર ફરિયાદી તથા તેમના સાથેના સહ આરોપી મહેશભાઈ વિપુલભાઈ વિઠ્ઠલભાઈ now વિરુદ્ધ સુરત શહેરમાં ઉમરા પોલીસ સ્ટેશન ગુના નંબર 259 of 2019. With regards to that also, sir, there is an FIR. Columns 177, 181, 182, 209, 120, 34, 406, 420, 114, 21/8/2019 ના રોજ કલાક 16 વાગે રજીસ્ટર થવા છે. તે ગુના તેમને ધરપકડ થવા પામતા જે ગુનાના કામે 22/8/2019 ના રોજ તેને સચિન રાજકોટ મધ્ય જેલમાં દાખલ થયેલા હતા. Now kindly see with regards to the offense in the jail which has committed. તે પછી 24/19 ના રોજ અરજદાર ફરિયાદી અને તેમની સાથેના સહ આરોપીઓ સાથે જેલમાં બનાવ બનવા પામતા જે બનાવ બન્યા બાદ તેમના દ્વારા 25/19 ના રોજ જેલ હવાલદાર વિરુદ્ધ રાજકોટ જેલમાં પ્રથમ અરજી આપેલ હતી. જે અરજીના કામે જેલ વિભાગ તરફથી સિનિયર જેલર શ્રી પ્રાથમિક તપાસ સોંપવામાં આવેલ હતી. આરોપી જેલ હવાલદાર આરોપીએ મોટું શૂટિંગ કરેલ છે તેને ન્યૂઝ પેપરમાં વાંચતા જેથી અરજદાર ફરિયાદી અને તેની સાથેના બેરેકમાંથી કાઢીને લાકડાના દંડાથી માર મારે હોવાનું તેમના નિવેદનમાં જણાવી આવ્યું અને તેમના વિરુદ્ધ જેલ થયેલ પ્રાથમિક તપાસ પણ જેલ હવાલદાર PM પટેલ દ્વારા અરજદાર ફરિયાદી તથા તેના સાથેના લોકોને માર મારેલ હોવાનું પ્રસ્થાપિત થાય છે. પરંતુ આક્ષેપિત વિરુદ્ધ કોઈ પુરાવા મળેલ નથી. અરજદાર ફરિયાદી નાઓએ 27/8/2019 ના રોજ જેલ મુક્ત થયા બનાવ સંબંધે પોલીસ કમિશનર શ્રી સુરત છે નાઓએ તરફ
Why evidence is not received against the
preliminary. Therefore, I am reading for that. અરજદાર ફરિયાદી શ્રી નાઓએ 27/8/2019 ના રોજ જેલ મુક્ત થતા બનાવ સંબંધિત પોલીસ કમિશનર શ્રી સુરત છે નાઓ તરફ પણ પુષ્ટિ કરી. જે સચિન પોલીસ સ્ટેશન અરજી નંબર 301 of 2019 23/9/2019 થી તપાસ થવા જેલ હવાલદાર PM પટેલ નાઓ વિરુદ્ધ 24/11/2019 ના રોજ ગુનો રજીસ્ટર થવા પામેલ છે. So it was after initially sir preliminary which was thought that there was no evidence. Thereafter,
But thereafter, since 2019,
let me
this Pasha Dada's filed quashing petition.
let me
No any relief, protected by him. Till today, no charge sheet filed.
Yes.
That is my allegation against the why since 2019 2020. I have filed 2020. Okay, my lord, that matter is not touched, my lord. But since 4 years, what I have done, my lord? Even my allegation against the not only Pasha Dada, my lord. He is jail hawaldaar. It was published in the newspaper. કે જેલની અંદર મારી પાસે જેલમાં 5-10 વાળા લુખ્ખા છે બહાર નીકળતા તને અને પરિવારને મારી નાખશે. It was published in all local newspaper in Surat, my lord. જેલમાં 5-10 વાળા લુખ્ખા ભૈયા બહુ છે તું બહાર નીકળશે એટલે મારી નાખશે. When he was arrested, this present applicant, and till today no charge sheet is filed, my lord, because only the Pasha Dada is a jail havaldar, my lord. That quashing petition નથી.
2020 ના રોજ નામદાર કોર્ટમાં ચાર્જશીટ કરવામાં આવેલ છે. You are not
But-
aware about this.
But my lord, my allegation not only Pasha Dada, my lord, this Nilesh
Kind of,
Vanparia. But
your
why not-
argument, you
But
are,
why not investigation against this, my lord, Nilesh Vanparia?
yes, anything for you, I will observe something against your client.
But
If
this
you
is-
are
This is
having
the incident,
such
I
attitude,
understand, my lord, 2018.
If the charge sheet is filed against PM Patel,
But
why
only
you are-
PM Patel, my lord. My submission is, this petition is specifically for the inquiry against the, my lord, this Nilesh Vanparia. Police is not done anything against Nilesh Vanparia, my lord.
yes, anything.
Please, madam. And I'm not, my lord, if you are not, should not.
Learned advocate, Mr. Manoj Simari, on instruction from client.
My lord, only.
The report which is submitted by learned APP is taken on record. In view of this learned APP, Mr. Simari does not raise this petition.
Only, my lord, my one submission, my lord, because of this application, FIR, and my lord, I filed this application, my lord. Sachin police station also, they may not, my lord, pressures to the, because he is one of the complainant, my lord, this Mahesh Sutaria and others person. And my lord, because of this influence of this Nilesh Vanparia, anytime they may be protect, my lord. That is only my
Why I
submission, ma'am.
enter into this? You can approach the appropriate authority in case of difficulty. Why I should observe?
Please.
The sixth permission, in view of this sixth permission, go withdraw this upon instruction. Dispose.
29, Mr. Aditya Mystery, London.
So this is against the order rejecting my application for handwriting expert opinion, which arises out of 138 proceedings. I moved on application stating that
After 5 years, what will be 2 years? Yes.
my instruction is this way is that the trial is pending, the complaint is yet to be examined. The only premises before my lords, for reason that I am here is, I moved before the learned sessions court, wherein two pertinent observations were made. First being that if the applicant, that is the accused, is not signed, it might be through someone else the check was signed. And the second observation which was made is that the complainant has not tampered with the check. May I just take my lords to the
Yes, yes.
so page number 29.
Yes.
So somewhere down Teva Sanjogoma.
Yes.
તેવા સંજોગોમાં ઇરાદાપૂર્વક ચેકનો ડ્રોવર 8/11 લખનાર હાલના અરજદાર અથવા તેમના જ મળ્યતા વ્યક્તિઓ દ્વારા અથવા તો રિવિઝનર દ્વારા ચેક તેમજ અરજીમાં અલગ અલગ સહી ઇરાદાપૂર્વક કરેલ હોવાનું શક્યતા નકારી શકાય તેમ નથી. તે અંગની રજૂઆત સામેવાળા તંત્ર રજૂઆત માનવા યોગ્ય છે. ફરિયાદી તથા રિવિઝનર ન્યાયિક કાર્યવાહી પૂરી થાય ત્યાં સુધી ટ્રાયલ કોર્ટના તેમના કેસની કાર્યવાહી યોગ્ય આવશ્યક બચાવ તથા હેન્ડરાઇટિંગ એક્સપર્ટ અથવા અન્ય એક્સપર્ટ ઓપિનિયન અંગે કેસની ન્યાયિક પ્રક્રિયા દરમિયાન આગળની કાર્યવાહી થઈ શકે તેમ વળી તેનાથી કોઈ પણ પક્ષકારોનો અહિત થાય તેમ જણાતું નથી. આરોપીએ પોતાના અંગત કસ્ટડીમાંથી ચેક ફરિયાદીને આપેલ છે. આમ બેંકના ચેકના હસ્તાક્ષર તથા ડ્રોવર્સની તેમજ બેંકના હકીકતનો સંદર્ભમાં ફરિયાદી દ્વારા કોઈ ગેરકાયદેસર કૃત્ય કરેલ હોવાનું આ તબક્કે ફલિત થતું નથી. તેવા સંજોગોમાં હાલની અરજી અયોગ્ય કારણસર it was rejected with cause. My submission being this way, sir, that today this observation, two observations, it's not neither here nor there, would prejudice my right. Suppose tomorrow if I have to move again an application for the handwriting expert, this two observation that it is made by someone else through me, and it is not made by the complainant. This, my respectful submission, sir, this will prejudice my right. Trial court rejected on two premises that I have the right subsequent to the trial with my right, and this application is made to prolong the trial. After which I moved before the learned sessions court saying that, sir, the check was, the endorsement shows two reasons. First being the signature differs, and second being it is not properly dated. And so page number 35 for a moment. This is a complaint filed by the complainant.
So which are the observations? Once again, read page 29.
So page number 29 તેવા સંજોગોમાં ઇરાદાપૂર્વક ચેકના ડ્રોવર આ જગ્યાના લખનાર હાલના અરજદાર અથવા તેમના જ મળ્યા વ્યક્તિ દ્વારા અથવા તો રિવિઝનર દ્વારા ચેક તેમજ અરજીમાં અલગ અલગ સહી ઇરાદાપૂર્વક કરેલ હોવાની શક્યતા નકારી શકાય તેમ નથી. તેમની રજૂઆત સામેવાળા પક્ષે રજૂઆત માનવા યોગ્ય છે. સેકન્ડ બિંગ ઓન પેજ નંબર 30 ચેકના હસ્તાક્ષર અથવા ડ્રોવરની સહી તેમજ બેંકની હકીકતો સંદર્ભમાં ફરિયાદી પેજ નંબર 30. The second observation. આ તબક્કે ફલિત થતું નથી. ફરિયાદી દ્વારા કોઈ ગેરકાયદેસર કૃત્ય કરે હોવાનું આ તબક્કે ફલિત થતું નથી તેવા સંજોગોમાં હાલની અરજી અયોગ્ય કારણસર. Sir, on first line, check na page number 30, internal page number 9. Check na હસ્તાક્ષર તથા ડ્રોવરની સહી તેમજ બેંકની હકીકતો સંદર્ભમાં ફરિયાદી દ્વારા કોઈ ગેરકાયદેસર કૃત્ય કરેલ હોવાનું
Then how court can dealt with your contention if court is not giving such finding? So every finding can be considered as tentative. Can't be conclusive finding.
But since some way or other way this will, because if my defense is to say that the complainant was not the due holder during time, then
Why notice is not issued?
sir, on first occasion I sought time for the instruction.
For
It
what
was not
purpose?
heard, but I mentioned. On second occasion it was gone into cutoff, after which I moved an application for fixing it. Then after it could not reach to the honorable court.
So now the matter trial is already prolonged for 2 years.
Sir.
Still pending?
Yes.
Why?
I sought.
You are asking for time.
Sir, I'm.
Yes. Take your chance, notice. Return. With date 7th of August. Please.
30, Miss Krupaben Limbachia, learned to be.
Also,
31, Mr. Jaimin Patel, Moksai Vyas, learned to be.
Complaint came to be lodged against me under section 138 of NI Act. And simultaneously, a summary suit also came to be filed, wherein two depositions were surfaced, which is at page number 24, which clearly established that there is no legally enforceable debt as on the date of check. Page number 20.
yes.
આથી હું નીચે સહી કરનાર. Thereafter, point number 1. હાલના કેસ નંબર વાદી તેમજ પ્રતિવાદી બંનેને અમે ઓળખીએ છીએ. આ કેસના વાદી સંજય.
Who is the petitioner?
I'm the petitioner who has been arraigned as accused in the complaint under section 138.
So he is practicing lawyer.
The
Practicing lawyer.
respondent who is the complainant was the practicing lawyer. Probably his sanad have also been suspended for 2-3 times in view of the illegality committed.
From Rajkot.
Please allow.
That will be after 2 months. August.
Please.
25-26. Otherwise not before me. Choice is here. I don't want to take matter.
Please.
32, Mr. Maulik Shah, leave note.
There is a leave note, and if you export from the concerned the honorable court had finalize the case from the court below. It is stated as road case faisal karama agel.
The learned APP has tendered the report received from the which police station? A division police station, Himatnagar. Whereby it is submitted that the charge sheet is filed on 22/7/2021 And court was also the case, criminal case, CC number, criminal case number 11791 of 2021 is also committed by order dated 19/8/2021 and was proceeded further and dispose of the said case by order dated by judgment dated 5/4/2020. Therefore, in view of this, though there is a leave not filed by the present petitioner will become infectious. Accordingly, dispose of as becoming infectious. Acquittal. Se ફેસલ કરવામાં આવેલ છે તમે acquittal એટલે and he has to write that છોડી મૂકવામાં આવેલ. Then dispose of. What is difficult?
33, Mr. Vicky Mehta, letter 50.
Madam, appeal on behalf of the matter may be permitted to withdraw.
Withdraw. Both the matter.
No, madam.
33.
33.
Learned advocate so and so for learned advocate Vicky Mehta seeks permission to withdraw this petition. Affidavit withdraw is taken on record.
34, Mr. Vicky Mehta.
Madam, I may be requesting to pass over. 1431.
What is your request?
Pass over, madam.
Why?
Madam, Mr.
Direction.
On his leg before the. Obliged.
35, adjourned. 36, Mr. MD Parikh. Letter 50.
Pass.
37, Mr. Kavit Kulasi, letter 50.
Yes. Charge sheet is filed. Where is Mr. Kuresh? Yes, charge sheet is filed.
This matter last time the honorable court directed the public prosecutor to get instruction because earlier been said that what is the role of the present.
Now charge sheet is filed during
That is a
pendency.
long day. Sir, in fact, I have stated in my application also, if the honorable court will see prayer clause. I have stated that criminal case number is also registered. This submission was made by my learned friend last time. Can you turn to page 12?
Yes.
Pending final disposal, you please to stay further with criminal case number 98 of 2008 pending before the court of learned principal senior civil judge. Santrampur, registered pursuant to CR number 44 of 2017, registered with Santrampur police station. Last time also you made the same statement, it is pending. I have stated in my petition itself, and therefore the honorable court directed him to verify that from the state charge sheet paper. Kindly state that what is the role played by the present applicant. Because if the honorable court will see page 46, the data entry work was given to one Mr. D.K. Damur, who was the extension officer, page 46.
Yes.
I was nowhere in picture. He is also one of the accused. And what is the allegation? It is not the allegation that amount is misappropriated by him also. The honorable court will find the complaint on page number 19, and the relevant the honorable court will find on page 21. Bottom, ઉપરોક્ત બાબતે તાલુકા વિકાસ અધિકારી સંતરામપુરે પોતાની કક્ષાએ તપાસ કરાવી તેના ખાનગી પત્ર 8/9/2016 થી જિલ્લા ગ્રામ વિકાસ એજન્સીને પોતાનો અહેવાલ આપવામાં આવેલ. તે અહેવાલમાં 2015-16ના વર્ષમાં ગ્રામ પંચાયત આમલિયાતના સમાવિષ્ટ ગામમાં ઇન્દિરા આવાસ યોજના હેઠળ કુલ 45 લાભાર્થીઓ પૈકી 1 થી 26, 28 થી 44 આમ 31 લાભાર્થીઓના બીપીએલ નંબર સાચા હોવાનું તથા 27 થી 40 લાભાર્થીઓના બીપીએલ નંબર સાચા ન હોવાનું અને 34 થી 34, 36 અને 45 પર લાભાર્થી નંબર સાચા ન હોવાનું પરંતુ તેમના નામ અન્ય બીપીએલ નંબરમાં સમાવેશ થતા હોવાનું જણાવેલ છે. So kindly see now who has prepared this list. The honorable court will find the list which was prepared by the Gram Panchayat, which I have placed on record on page 24. It is prepared by Sarpanch and Talati cum Mantri. On page 31, the Honorable Court will find. The list is also not prepared by me. On page 31, the Honorable Court will find. ઉપર મુજબના લાભાર્થીઓ આજની સભામાં સંભવિત યાદી નક્કી કરી ઠરાવ કરવામાં આવે છે જે સર્વાનુમતે મંજૂર કરવામાં આવે છે. The Honorable Court will find the signature of Sarpanch and Talati cum Mantri, and therefore the Honorable Court directed them that from the charge sheet point out that what is the role played by the present applicant who was working as a TDO at the relevant point of time, and number 2 is the MIS. He is a coordinator, and therefore the matter was rested there. In the entire charge sheet, there is no allegation with regard to present applicant number 1 and 2. The statement or the list was prepared by Sarpanch and Talati cum Mantri. The entry work was done by Extension Officer Vistran Adhikari.
R.K. Goyal is a TDO.
R.K. Goyal, yes, R.K. Goyal is
Present
TDO, yes.
petitioner.
Yes, first petition number 1 is TDO. Number 2 is coordinator. A specific question was put to the learned public prosecutor that from the charge sheet show a statement that these present two applicants are involved.
What is present status of the trial?
Charge is not present.
Officer says that it is at the stage of.
Last time also it was a stage of.
Of the stage of.
Let them make, sir, because what has happened last time also, the same
Trial
thing was
is
submitted.
commenced, then there is question.
Sir, what I'm requesting the Honorable Court, charge sheet was filed when I approached this Honorable Court.
Whatever.
I have stated in application also that complaint is also, criminal case is registered pursuant to complaint. Let them point out a single state from the statement of the witness that number 1 and 2 has played this role.
Why I have to conduct the mini trial here?
No, I'm not saying that, sir. I will not even endeavor to request the Honorable Court to do that. What
If
I'm
trial
requesting-
is commenced, then there is no question.
Sir, because my instructions are there, charges are not framed. I will again verify it because we have checked up from the online.
His officer is here. So trial is commenced, Mr.
It is at the stage of evidence. It is what my-
Evidence means what?
We can come at 2:30 and we will verify it.
કોઈનો એવિડન્સ લેવાનો છે કે વેરીફાઈ એમના ત્યાં તમારા પીપી ને એમને પૂછાવી લ્યો. Ask him.
Sir, we also
2:30.
verify.
2:30.
Yes, yes.
Get the exact detail.
Yes, sir.
My oral instructions are that petitioner is passed away. I have tried to bring the death certificate, but I was.
So
My
what is
friend-
your request?
It would be infructuous.
Learned advocate, Mr. What is your good name?
Noman S. Qureshi.
Noman S. Qureshi. Upon instruction submits that sole petitioner Amrut Bhai Thakur Bhai Patel
Please, ma'am.
is passed away during the pendency of the. However, he is not having any document at present with him. But he has verified the same fact. Therefore, the present petition abated for the petitioner and accordingly disposed of as abated.
Please, ma'am. Obliged.
A petitioner who is sole petitioner. Yes, yes. Notice remain unsolved on number 2.
Notice of it. Notice of.
My
lord, that there are 3 petitions in which notice remain unsolved, my lord, that according to me has become infructuous because I have been acquitted.
So
This is the
39.
judgment.
Yes.
Lordship is having number of.
First matter, serial number 39. Sorry.
One second, my lord.
So that may not be
One
missed.
five eight double two.
15822. In which acquitted, in which I am acquitted. This is it.
Let me look at Mr. Nanavati. SI Nanavati, appeal for Sir Nanavati. The standard judgment pass in criminal case, copy of judgment pass in criminal case number 1506685 of 2013. By additional chief metropolitan magistrate court number 5 on 1/4/2022. In view of this present petition, prayers in present petition has become infructuous. Accordingly, disposal has become infructuous.
Well,
Yes.
that second petition, that is 15848.
Yes.
Well, that by passage of time, now it has come up the evidence stage. But since I am unable to contact my client, Lordship may say that since it is at evidence stage,
Let the trial maybe.
let the trial to over. And I do not invite any reason for that. So Lordship may dispose of one.
The present petition is.
Now Lordship may come to that third petition.
The present petition is right for hearing and at the stage of evidence in view of this. The present petition, prayers made in the present petition becoming effective and accordingly disposed of. Learned advocate Mr. Nanavati does not rest for any reason. Hence dispose of this.
Now Lordship may have it, my lord, the 15849.
Yes.
My lord, the FIR is, my lord, at page 21. My lord, before the going to that, my lord, what is the real disputes?
Yes.
It is in the civil nature, in this sense, my lord, the original two owners have sold the parcel of land to me for which I have purchased for rupees 63 lakhs by registered sale date. One Lalbhai, who's according to him, the same original owner has entered into some type of satakat or the agreement for selling of the same land. So Lalbhai has filed a suit against my lord, the original owner, as well as against my lord, myself. My lord, the original owner has sold to my lord, the original owner has sold to me by registered sale date. That has been not stated in the my lord, the suit. Suit is only for possession. And that suit came to be dismissed for default, my lord, since it has been not prosecuted any further, my lord. Keeping that background in mind, my lord, this present complainant is a cousin brother of that Lalbhai. And therefore, he is interested in, my lord, the filing. There are 5 types of complaints filed to Lordship at disposal. One filed by driver of that, my lord, complainant. One filed by the complainant. Third filed by the, my lord, the neighbor. Fourth filed by the now Savita Ben, who is also happens to be the one of the neighbor. So, my lord, he only wanted to see that the so many complaints are filed.
On same day.
So, no, on different dates, but in the span of that. So, my lord, I can be, my lord, the book under the PASA. And therefore, when I have filed this petition, I am protected also by this honorable court's order that no PASA should be invoked against me. In this background, Lordship may come to page 21.
Yes.
Well, second number paragraph. આજ રોજ 11/9/2016 ના રોજ રાતના 8:30 વાગે હું મારી મોટરસાયકલ લઈ રિંગ રોડ પેટ્રોલ પુરાવામાં જતો હતો ત્યારે આ શૈલેષભાઈ ભરવાડ, that is myself, તેમની ફોર્ચ્યુનર ગાડી લઈને આવેલા અને મને રામોલ વટવા રોડ ઉપર સો ઓફિસ સામે રાખી શૈલેષભાઈ મને જેમ તેમ ફાવે ગાળો બોલવા લાગે. So this is abusing language, one allegation. જેથી મેં ગાળો બોલવાની ના પાડતા શૈલેષભાઈ એકદમ ઉશ્કેરાઈ ગયેલ અને મને ગધડા પાટુનો માર મારવા લાગેલ. એટલામાં તેમની સાથેના બીજા 2 અજાણ્યા માણસો ગાડીમાંથી લાકડીનો દંડો લઈ નીચે ઉતરેલ અને મને થાપાના ભાગે 2-3 ફટકા મારેલ અને શૈલેષભાઈએ મને કહેલ કે મારી પાસે પિસ્તોલ છે, જો હવે પછી રસ્તા બાબતે મારી સાથે બોલાચાલી કરી છે તો તને મારી નાખીશ તેવી ધમકી આપી આ ત્રણેય મને ગધડા પાટુનો માર મારવા लागेल. જેથી મેં બૂમાબૂમ કરતા આ ત્રણેય તેમની ગાડી લઈને ભાગી ગયેલા. એટલામાં મારો મિત્ર પ્રકાશભાઈ આવી જતા, ક્યાંથી આવી ગયો પ્રકાશભાઈ ખબર નહીં,
108 માં ફોન બોલાવેલ અને શરીરે મૂળ ઈજા થયેલ હોય જેથી એલજી હોસ્પિટલમાં લાવેલ છે. હાલ મારી સારવાર ચાલુ છે. હું સંપૂર્ણ ભાનમાં છું વગેરે. નાઉ લોર્ડશિપ માર્ક હિયર માય લોર્ડ that he said that રસ્તા બાબતે મારી સાથે because this my lord complainant is having the land which I have purchased adjoining to me also. Lalbhai has my lord filed a suit. So in that background now lordship has a charge sheet my lord. The lordship will find it on page 22.
Yes.
Well, first column આરોપીઓ બાલો that other બે જણ અજાણ્યા માણસો એ આજની તારીખ સુધી they are absconding. In column number 2 nothing has been mentioned. My lord, the lordship may come to last column 323. Now my lord 323 my lord is a simple injury. Then lordship may will find it 294 K, that is my lord the abusing language. અને 506(2) મારવાની ધમકી 114. now બીજા બે માણસો મળ્યા જ નથી. 114 can't be invoked. now મારવાની ધમકી 506(2). now that is the only my lord the allegation against me. now lordship may see my lord the statement of this Prakash Bhai, which lordship will find it because Prakash Bhai came my lord that he said. my lord Prakash Bhai himself is saying that incident થયો ત્યારે હું નહોતો, હું પછીથી આવ્યો છું. at page 96, I'm sorry. Well, a type copy is at page 97. Lordship may please oblige me by saying that, my lord. Well, third paragraph, somewhere fourth line. પૂછતા લખાવું કે ગઈકાલ 11/9/2016 રાતના 8:30 વાગે હું મારી મોટરસાઇકલ લઈ રિંગ રોડ પર જમવા જતો હતો ત્યારે રામોલ વટવા રોડ ઉપર KGN હોટેલની સામે મારો મિત્ર નવીનભાઈ ભરવાડ રોડ પર નીચે પડેલ હતો. સો he has not seen the incident, મારવાનો બનાવ. જેથી મેં મારી મોટરસાઇકલ નવીનભાઈ પૂછે કે રામોલ ગામમાં ભરવાડવાસમાં રહેતા શૈલે. So he has not seen me, my lord. It is the hearsay. અને અજાણ્યા માણસે મળીને મારે માર મારેલ છે વગેરે. લૉર્ડશિપ મે સી લાસ્ટ પેજ 98. આ ઝઘડો થતા મેં નજરે જોયેલ નથી. Now, my lord, there are two other witnesses whose statements are recorded at page 103 and 107. For 103, my lord, is one Mr. Hakim Ali, Imam Ali. Third paragraph. 12/9/2016 આપ સાહેબને તપાસના કામે IPC 323 વગેરે પર જે ભાવે પૂછતા લખાવું છું કે ગઈકાલ તારીખ 11/9/16 રોજ 8:30 વાગે હું તથા મારા ભાઈ બંને અમારા ગલ્લા ઉપર હાજર હતા. દરમિયાન અમારા ગલ્લાથી થોડે દૂર આગળ, સો નોટ એટ ધી સમ ડિસ્ટન્સ, 108 વાન આવેલી જેથી હું તથા મારો ભાઈ ત્યાં ગયેલા. સો આફ્ટર ધ ઇન્સિડન્ટ વોઝ ઓવર they both have gone. અને નવીનભાઈ થકી જાણવા મળેલ. સો નવીનભાઈ has told that શૈલેષભાઈ ભરવાડ અને બે અજાણ્યા માણસો complainant says. 107, my lord, same similar type of statement of my lord the one Mr. Mehboob Mia, Rasul Mia. My lord, fourth line in last paragraph on page 107. ત્યારે મારા ગલ્લાથી થોડે આગળ રામોલ વટવાજ પર 108 વાન આવેલી જેથી હું ત્યાં ગયેલ અને મને વાતોમાં જાણવા મળે કે કોઈ ઝઘડો થયેલ છે અને તેમાં એક ભાઈને સામાન્ય ઈજા થઈ છે જેથી 108 વાન આવી છે અને વાનવાળા ભાઈ તેને દવાખાને લઈ જતા રહેલા. ત્યારબાદ હું મારા ધંધા પર જતો રહેલો. આ લોકોને હું કોઈને ઓળખતો નથી વગેરે. Now lordship may see my lord the medical certificate, my lord, at page 110. All of the incident is of 8:30 p.m. of 11th September. This is to certify that Sri Naveenbhai Barwad was brought to this hospital at 9:50 p.m. on 11th September without police yadi. This may be also noted, my lord. He was treated as an outdoor patient and for following injuries, and he left the hospital on 12th September 16 at 12:30 early morning. એટલે 8:30 રાત્રે 11મી ના 8:30 પછી એટલે 12:30 વાગે એને ઉઠલેલા. Now that suit lordship will find it at page 31 in this background. Lordship may see the suit is filed by Lalbhai Barwad, cousin brother of this complainant. Defendant number 1 and 2 are the original owner of the land. 3 is myself. Or slightly to save the time, my lord. The lordship may come to the prayer clause at page 34, paragraph 7A. સજુ દાવારજી પેરા એકમાં દર્શાવેલ દાવાળી મિલકતનો કબજો આ કામના પ્રતિવાદીઓ કે તેમના એજન્ટો માણસો પાવર ઓફ એટર્ની હોલ્ડરો મળતિયા વગેરે અમો વાદી જોડેથી ગેરકાયદે રીતે કબજો લેવડાવે નહીં કે અમો વાદીના કબજા પર દાખલ કંતરાયો હતો કે તેઓ કામ ચલા મંડાયો આપશો. So it's only for possession. It came to be, my lord, dismissed at page 70. My lord, I've got a status report of this suit, my lord, that it is dismissed for non-prosecution. Well, after the IO purchase and the register sale deed, it is mutated also in my name. And the 7/12, the mutation entry lordship will find it at page 78. So, this is only with a view to bring the pressures. The totally 5 complaints are filed. No doubt we are in the caution only for 3 out of that. 1 where I have been acquitted. Second one which lordship has just now disposed of, and third one is this.
Yeah, what is stage?
My lord, as per the, I have got a status report. Charge is not framed, my lord, till today. I have got a status report. Therefore, I am only pressing for this petition because the other 2 are not the.
Yes. Yes.
Though there is an obligation. Kindly see the FIR which is a paid complaint.
Yes.
Where I am my respectful submission is that Shailesh એ મને કહ્યું કે મારી પાસે પિસ્તોલ છે અને ઘરે પછી રસ્તા બાબતે મારી સાથે બોલાચાલી કરે છે અને તેને મારી નથી એવી ધમકી આપે છે. So that is one of the allegation. Kindly see the charge sheet which is in the charge sheet also they ધ્યાનથી મારી નાખવાની ધમકી and so this is now charge sheet has been filed and with regards to the status, it is coming up tomorrow before the government trial. It is on 28/6/2020, which is at the stage of process to work. As far as the other FIR is concerned, which was one where the trial has been at the stage of commencement, and the other one is just there in one of the matters. But the nature of the FIR is similar. Therefore, not exercise this. With regards to that similar modus operandi of giving threats to the persons involved, therefore my respectful submission will be that my words, since the charge sheet is filed in the present matter.
Petition is filed after filing of charge sheet.
Yes.
Otherwise, I can consider your submission.
But only with regards to
Looking to the even statements also that they are hearsay.
with regards to I am not
Except this whatever.
not having the judgment, the citation. But with regards to though the civil suit was filed, which was dismissed for want of non-prosecution. Because with regards to that also, both can go parallelly. There is no.
That is not. That is the cause for what is. I think a submission of senior counsel to that effect.
And since the civil suit was filed, and then how much the present complaint is. But my respectful submission.
Normally, I am not inclined to exercise, but looking to the totality of facts, that it is not allowed.
I'm obliged.
Present petition is by following prayers, considering the fact that there are the so and so.
My lords may only observe that the complainant is served, but has chosen not to do it.
Is served? Yes, complainant is served. Though complainant is served, he has not filed any appearance or protested this petition. Facts of the case, so and so. Then the advocate Mr. Lahoti submitted that the present petition is filed after the filing of charge sheet. On their reading of the FIR, it transpires that the FIR is filed with a malafide intention, as there is some civil suit proceeding is filed by the suit is filed by the present complainant, Lala.
No, my lord. The cousin brother of the present.
Cousin brother of the present complainant. This civil suit number 1580/2016, people of the city civil and sessions court, which was dismissed for want of prosecution during the pendency of this petition, dated by order dated 30th April 2022 by the Supreme Court. In this background, he has submitted that the present petition is filed by indicating that the present complainant has filed various complaints against the security guard, driver, cousin brother, encroacher of the
And given chart on page 11 of the petition. Of the bike.
and where the present complainant is different, but is they are related to the present complainant. Lalabai. Lalabai is complainant.
Yes.
Lalabai is there.
Naveen Bhai is a complaint.
Lalbai
is a cousin brother.
Lalbai is
Lalbhai is my lord not complainant. Complainant is Naveen Bhai. Naveen Bhai, Bhagu Bhai, Bharwad.
who is cousin brother of Lalbai.
Cousin brother of Lal.
Naveen Bhai. So who is cousin brother? And complaint is filed by the different complainant who happens to security guard. Security guard, driver, cousin brother, encroacher of the land bearing survey number 327 of Convert, etc. He has also drawn my attention towards the fact that from the statement of the persons whose statement were recorded by the police, namely Hakim Ali, Imam Ali, Sayyid and Maji, son of Mahmoud Mia, Rasul Mia Malik. It transpires that both of them have visited the place of so-called incident after the incident is after the incident is over and they have not seen anything. Incident they have reached the place of incident and they have not actually seen the incident is occurred. Now, considering the fact that it transpires and therefore he has submitted that the present complaint is filed with a view to pressurize the present petitioners and also with a view to harass the present petitioner by giving color of criminality to the essentially dispute which is going on, which is pertains to the civil proceeding. And therefore, he has submitted that in view of judgment of Pajanla and other witness, this court can exercise power by quashing the FIR is consequential proceeding. That means charge sheet and proceeding of criminal case. If it is found that the such complaint is filed, which amounts to abuse of process of law. Therefore, he is praised to allow this petition. For contra, Mr. Joshi, appearing for the respondent, has submitted that on their reading of FIR, it transpires that the alleged incident under section 323 294 B and 5062 is ingredients of a offense attracted from the mere reading of a file. And since the charge sheet is filed pursuant to the said FIR, it is not proper to interfere at this stage, as now trial is also likely to proceed as per. And therefore, he has submitted that this court should exercise powers under section 482 as well as article 226 of the Constitution, 226 of the 227 of course very sparingly and praise to dismiss this petition. It is relevant to note that though the notice is served in the present petition, original complainant has not appeared in the present proceeding nor engage any advocate to oppose the present petition. Therefore, I have considered the relevant aspects of the matter. I have also perused the FIR and also the charge sheet and papers of charge sheet. It transpires that essentially the dispute is occurred pertains to some land which is adjoining to the land of the complainant, cousin brother of the complainant, and the civil suit proceeding is filed by the cousin brother of the complainant, which was going on at the relevant point of time. It also transpires from the record that thereafter the complainant and other persons who are near relative of Lalabai have filed various complaints in within that particular time span before the various police stations. Same police station or various police stations?
No, different police station.
Before the different.
Vatva and Ramor police.
Different police station with a view to arrest the present petitioner and pressurize the present petitioner. It also transpires that on their reading of the provisions of section 323 294B and 5062, which are reproduced as under genuinely considering the totality of facts and circumstances are not genuinely requirement of the ingredients are not genuinely satisfied. Moreover, it appears that the complainant has tried to pressurize the present petitioner by giving color of the dispute, which is arising from the civil proceeding by giving a color to such dispute of criminal as such no believable offenses by believable material is available on the record from which it can be said that the proceeding of the trial pursuant to the impugn FIR and charge sheet filed against the present petitioner is required to continue. On the contrary, perusing the material by way of statement of the witnesses which are indicated as above, it transpires that there is no sufficient material against the present petitioner on basis of which trial is required to be proceeded further, and therefore no fruitful purpose also to proceed with the proceeding of trial. Therefore, the in view of the judgment of the case of the general, it is appropriate to post the proceeding of FIR and charge sheet in pursuant to the charge sheet, the criminal case registered against the present petitioner. Accordingly, the proceedings are posted.
Oblate.
I did not disturb the lordships at this time. It's the next matter that I appear with Mr. Jasani. The complainant's advocate has filed a signal. Both of us are in separate matters before a division bench at 2:30. Would your lordships kindly accommodate to 12 or whatever convenient date to lordships?
27th.
27th. Lordships. 8 to May I
Yes.
request?
Yes,
Look at item number 20. That 330 board. I forget the name, supplement. Board. Separate board.
yes,
330 board.
yes, yes.
May I request?
Separately notified.
Separately. May I request to have it on Monday?
Right?
I don't want to pay penalty. I have lost my file. Advocate on record did send the file in time, is not to be.
Sanat Pandya.
Sir, he did send the file in time on Saturday. My office has been goofed up somewhere.
Let it be on Friday. Then Friday.
This Friday. This Friday. This Friday, Sunday. That's why I'm
And
saying.
First Saturday.
Saturday, no.
Saturday.
Saturday,
First.
not your object.
First.
Kindly.
Yes.
So Mr. Pandya comes from Nadia. That's why we're not here. He lives in Nadia.
Yes, yes,
He's practicing here.
yes.
Therefore, it's if convenient. But this is also a grace that your lordships are showing. But then request is on third.
Third.
Please, your
Third.
Serial number 37. I have taken instruction. Charges are framed, but no witness has been examined. Charge is framed, but no witness is examined.
It's a commencement of trial. It's a commencement of trial.
Charge is framed. I cannot because I also checked up. Would my lord not?
I am not.
Please. Then in that case, my lords may dispose it of saying that
It's
charge
a-
is framed, but this disposal will not come in the way.
Yeah, by keeping all the contention. Serial number 37, learned advocate. Mr. APP. Who is appealing? You, Mr. Joshi, has submitted that the charges are framed in the trial. Learned advocate, Mr. Joshi, Premal Joshi, appealing for the petitioner, has also confirmed the same and has submitted. You are not pressing or shall
Lordship may
I?
pass appropriate order. I mean, since it is the charge is framed, it will not survive.
Learned advocate, the prayers in present petition will not survive and accordingly dispose of has become infructuous. However, the all the contention raised in the present, it is open for the petitioner to take all the contention available in the present petition.
And this disposal will not come in the way.
This will.
Please, sir, I will.
Content,
Please, sir.
I have kept.
Please, sir.
Serial number 75, separately notified board.
Yes.
So all petitioner is expired. I have submitted the date certificate, so it will abate it.
Separately notified board, serial number 75.
Lordship.
Learned advocate, Mr.
I have
Kumar
produced date certificate, 16 July 2021 is expired.
Trivedi has, KK Trivedi has tendered the death certificate of sole applicant Chandrakant Shanabai Javeri, who is expired on
16 July 2021.
16 July 2021. In view of these petition stand abated as sole petition applicant is expired. Accordingly, petition is disposed of as abated.
Okay.
88, madam. I am 88 serial number.
Serial number?
88.
Yes.
I am mentioning on behalf of Mr. Bada. We have instruction to withdraw this petition. So madam may consider this.
In separately notified or daily board? Daily board. Serial number 88. Zubin Berda.
Yes.
Learned advocate so and so for Zubin Berda submits that upon written instruction received from the client, he seeks permission to withdraw. The communication dated 20th June 2023 addressed to the advocate Mr. Berda is also placed on record. In view of this, the said communication is taken on record. Accordingly, petition is disposed of as withdrawn. Yes.
I have been informed that the matter is in NPP because I called for the immediately if it can get day after Friday or
Friday.
yes, so I
Friday.
can produce that.
Friday, top of the board.
Yes, yes.
Actually, Yatin Baiwani, top of the board. Right?
Lordship, serial number 61. I'm mentioning behalf of Mr. Sharma. The trial is over, so Lordship, permission to withdraw.
61.
61 daily.
Learned advocate
Kuldeep Sharma.
Which board 61?
Se-
Kuldeep Sharma. Yes. Kuldeep Sharma. 1709 October. You are
Shahrukh Pathan.
Shahrukh Pathan on behalf of Kuldeep Sharma submits that since trial is concluded, he seeks permission to withdraw. Permission is granted, petition is disposed of. Yes.
115 is separate notified. Permission to withdraw. The original, this was filed against the 20%, order of 20% deposit in 138. The trial was over, 2 have been acquitted, 1 has been
So
convicted.
trial is
Appellate court has remanded back, but that 20% doesn't survive.
learned advocate Mr. S.S. Acharya submits that during pendency of the petition, the trial is concluded and the the petition is prepared against the interim order passed.
20%.
That order passed for depositing of 20% of the amount. In view of this, the cause is not survived, and therefore he seeks with permission to withdraw this petition. Permission is granted. Petition is disposed of.
Your Lordship, purport serial number 7 on behalf of Mr. K. S. Chandrani, we seek permission to withdraw the application as the parties are settled. Purport serial number 7.
Purport is yes, in the morning.
Yes, Your Lordship.
Serial number 7. Purport no you do both. Special. Learned advocate so and so for case and seeks permission to withdraw this petition. As party,
Have settled.
the parties have settled.
Yes,
that
Your Lordship.
permission is granted. Petition is disposed of as withdrawn.
Oblige, Your
Serial number 26, Your Lordship. I'm mentioning on behalf of Ms. Vyas. My request for 10 days time. We have lost the contact with client. We are trying to establish the contact. 10 days time.
Right.
26 in Delhi.
એકવીસની આપો 27 પછી આપો
28. I'm ready.
May I request now? Serial number 83 months. Yes, serial number 83 months. Respond number 2 is answered. May I request for direct service so that I can serve it?
83 SM Sojatwal
Please.
submits that notice remained unserved to respond number 2. Therefore, he prays for fresh notice returnable on 4th of August. Direct service. Yes, Miss.
Serial number 36. We are on last occasion, Honorable Court has issued notice to respond number 2. It has been served through police station.
Unserved.
No, it is, board says that it.
Yes.
It's been served. May I request on 30th, it might be settled because
30th. Rismi.
obliged.
Top of the board.
Yes.
My Lord, serial number 34. Here, I may be permitted to withdraw this matter as charge sheet is filed, my Lord.
Serial number
34 in Delhi board.
learned advocate so and so for Vicky Mehta seeks permission to withdraw as charge sheet is filed with a view to avail appropriate remedy. Permission is granted. Dispose of as withdrawn.
Also, my Lord, 65. May I request for some time?
65. Why?
As Mr. Jalunwal appears in this matter and he has some difficulty. to do so.
Ultimately,
Any short
matter
date
is matter.
next week, my Lord.
Let it be called out.
Please.
Otherwise,
Please.
39 is separately notified. Notice is not so. So earlier direct service was permitted. May I request to place not with direct service through the concerned police station.
serial number
39 is separately notified.
39 specially notified for. Notice is remain answered to respond number 2. Therefore, learned advocate for the petitioner prays for press notice. Notice that the press notice issued returnable on 7th of August. Direct service through the concerned police.
My matter, papers of my matter that has been made out, my lords. And requesting for consent person is taken.
Consent proceeding. I will notify the, let it be called out. It will be called out after the mentioning is over.
Please, ma'am. And
Same, I'm on behalf of responding.
Same matter.
complainant. Let,
Yes.
let it be called. Yes,
My lords had asked me to come at 2:30. Serial number 6, that liquor matter. If my lord, on behalf of Mr. Remote,
yes,
taken instructions, my lord. The client wants to press the matter further. My lords may pass an order.
order.
Yes.
Yes,
If I may make another request, my lord.
that premises is used for storage of.
This is that matter, my lords, where
Yes, yes.
charge sheet suggests that the muddamal was recovered from the rented premises. From accused number.
The present petition is filed for following prayers. Learned advocate, Mr. What is your good name?
Anik Kadri.
Anik Kadri for the Jay Prakash Remote has submitted that though the charge sheet is filed, but in view of the order passed by the coordinate bench in a different matter, that is criminal miscellaneous application 3273 of 2017. Court has observed that even in such case, the charge sheet is not required to be filed, where the no other evidence except the statement of co-accused is available on record. He has therefore submitted that the present petitioner is otherwise also the son of the deceased person in whose premises it is the goods which is found, the goods involved in the offense is found from the said premises, and therefore considering the papers, the FIR and also papers of charge sheet, except the statement of co-accused, no other evidence is available. And therefore, he prays to quash this petition, proceeding, impugn FIR by exercising power under section 482 in view of the judgment of Vajanlal and other judgments. Per contra, Mr. Joshi, you are appealing, Mr. Joshi, appealing has drawn my attention towards there is a report or
From the papers itself, madam, I was saying, page 17, my kind of.
17. From the statement of the from the complaint itself, where it is found that the huge quantity of the liquor is found from the premises where the father of the present petitioner is owner of the premises and which was given on rent. That is a rent. It also he has further submitted that
Page 20 is the copy of it.
from the Panama also it reveals that the bottles of the liquor, about 126 bottles were recovered from the said premises, which is owned by the other of the present cases, and petitioner is also aware about the owner this premises which is rented to the such person, and therefore he has submitted that it is duty of the owner of the premises to see that the premises which is rented to the per person is not required, is not misused by the tenant or person who is in possession of the premises. And therefore, it cannot be said at this stage that petitioner is not, there is no involvement of petitioner. and petitioner is merely involved on the basis of statement of co-accused. And there is sufficient material for which the trial is required to be proceeded. And therefore, he has that present petitioner, this court should not exercise power, which is otherwise required to be exercised sparingly under section 482 of the criminal procedure. I have considered the rival submission made at the bar. I also consider the fact that it is true that this court in the other set of circumstances has observed that in the petitioner should not be implicated merely on the basis of statement of co-accused. But looking to the effects of the present case, more particularly, the liquor is found from the place of the premises is owned by the deceased father of the present petitioner, and there is some allegation is made looking to the papers of charge sheet and FIR against the present petitioner also. I think this is not, it is not appropriate at this stage to exercise my discretionary powers under section 482 as such aspects are required to be tested at the time of trial. And while exercising powers under section 482 of the criminal procedure code, court has only to examine whether or not the prima facie offense is made out against the accused. Therefore, in view of the judgment of Niharika, which is Niharika infrastructure, which is there right, para 70 or 80 is conclusion. 80 Niharika infrastructure. This court is of the opinion that this is not fit case where the court should exercise powers under section 482 of criminal procedure. Accordingly, petition is dismissed.
May I make a request for serial number 16 in the daily board? This is a one.
80, which citation? Give the citation. Reported in which? Yes.
Lordship. Serial number 16, bunch of 5 matters, my lords, all connected. This is for consent quashing. My lords, here the complainant in 2 FIRs is a senior citizen, resides in the United States of America. My lords, he is traveling to India. He's coming for this matter only. My lords, my request for next week or 2 weeks after.
Why? The matter earlier also matter was listed and
my lords, at that time he had remained present, my lords. It is recorded, my lords. His presence had been recorded. He had remained present on the last occasion whenever it was at that time called out, my lords. His affidavit is also on record. But if his presence is required, he is traveling, my lords. He is coming to.
Presence is otherwise also required.
My lords, therefore I'm requesting for some time, my lords.
No time. 2021 matter. Why you are asking for time?
My lords, earlier he had only one request, my lords. Because he's one senior citizen, my lords, he has moved with his children to the United States. Obliged, lordship. Grateful.
Citation. Yes. Consent possible.
Serial number 147 in the SNB board, no, the client has passed away, it's a quashing, so it may be disposed of, it will be abated, no? Or I may withdraw this matter.
147 of
the SNB, special
notified
notified board.
147.
So quashing, there are 2 matters, out of which one matter is my matter, no? In that matter, the petitioner has passed away, no? He was an accused in the FIR, he had sought quashing.
Sole petition.
In my petition, yes. There's another petition of which I am not one of the 2 petitions. This is 2015. SCRA 6178 of 2015, my lord.
Six. 699, 6.
6178 SCRA.
6178. Mr.
Praveen
Padris
Chandra.
Raj, advocate for petitioner, standard, the death certificate of Praveen Chandra Rangil Das Kapasia, who is sole applicant in the present application. Expired on 10/5/2017. The death certificate issued by Surat Municipal Corporation is taken on record. In view of the state, the present petition stands abated according to dispose of as abated. Rest of the matter. What about the rest of the matter?
That I am not aware. That will come in.
પછી data આપી.
I'm
કોઈ
applying.
પણ data આપી. બાકીની બે જુદી પડવી પડશે.
I'm applying.
3માંથી 1 હતી બાકી બે. Yes, I got consent copy. પણ એ તો આની બે છે. અચ્છા, ઓકે. 617 બે ઓલામાં પાર્ટમાં.
Consent. For court board, serial number 6, please have a copy of that. Because we are running consider.
Yes. Where is your complainant?
Yes, ma'am.
Where is your affidavit? You are for the
Yes, my lord, I'm on behalf of respondent.
complainant.
Complainant, my lord.
આવો આ બાજુ આવો, વકીલ સાહેબ પાસે. શું નામ આપનું?
નરેન્દ્ર ઝા.
નરેન્દ્ર ઝા. શેના માટે કમ્પ્લેન કરી હતી? ફરિયાદ.
એટલે સર્ટિફિકેટ ને ડુપ્લિકેશન ની બાબતે.
હવે કેમ નથી તમારે ચલાવી આગળ?
હવે હું રિટાયર્ડ થઈ ગયો છું અને હાર્ટ પેશન્ટ પણ છું, એટલે હવે બધું સ્ટ્રેસ નથી.
તો પછી એટલે ફરિયાદ ખોટી કરી હતી એવું નથી, મિસ્ટેક થી કરી હતી. આમાં લખ્યું છે તમે એવું કે તમે ભૂલથી ફરિયાદ કરી હતી. ભૂલથી કરી હતી કે જાણી જોઈને કરી?
ના ના
નથી ખ્યાલ. વકીલ સાહેબે કીધું એટલે કરી દીધી એવું હતું? આ ફરિયાદ રદ થઈ જશે, વાંધો નથી ને આપને? તમે આ એફિડેવિટ કરી છે બરોબર છે? માન્ય છે તમને? કોઈ દબાણ નથી ને?
ના ના.
સારું. When the matter is called out. What is your good name?
Hiren Kandera.
Hiren
Kandera.
Kandera, appearing for the complainant as tendered the affidavit. You have filed your wakalat number?
Yes, it is already there.
And of the one Mr. Narendra Jha, son of Rajnikant Jha, and has submitted that now the parties have settled the matter and the complainant has no objection if the complaint is forced impugned. Considering the same, that the court has inquired the Narendra Jha, who is personal complainant, who is personally present in the court, about the veracity of the evidence made in the complaint affidavit, and he has submitted that he has executed this affidavit and he has no objection if the complaint is forced. Therefore, considering the same, Baki, the appellate.
Please, I'm on.
Yes.
120, mutual fee,
Matter regarding the matrimonial dispute losses. 498A. Complaint with present losses.
$498 losses. Yes, who is for the other side?
Complaint with present losses. Very much.
Who will identify? Nobody has identified.
I will identify losses.
I will accept.
This sort of affidavit is not, no affidavit, sir. How I can accept this, sir? Say, here also explaining that nobody has signed. Notary is also putting his signature and seal without recording who has identified. હા બેન બોલો શું નામ આપનું? પાયલબેન. શું હતી તમે ફરિયાદ શાના માટે કરી હતી? કોની સામે કરી હતી?
My spouse, my husband, against my husband.
Against your husband. Okay. So now there is no
No.
dispute. બે complaint છે?
No, process second matter is a domestic violence act.
Yes. When the matter is called out, the complainant Payal Ben Arunbhai Patel is present in the court. She has filed affidavit and copy of the Aadhaar card is also produced on the record. And she has submitted them. She has no objection if the complaint is quashed. In view of this, the respective complaint 6997 Mike BG 7004 7004 માં છે domestic violence. પેલી છે 498.
Highly object.
ચલો.
I'm appearing on behalf of Mr. Dave. This is a consent causing offense punishable under section 323, 506, subclause 2. Original complainant is present and accusers are present.
Affidavit. શું નામ છે આપનું? મોનિકાબેન. ફરિયાદ તમે કરી હતી? શેના માટે કરી હતી?
પાકલ ઉપર અને પપ્પાને છાતી પર છે ને વધારે આવડે ભાર કર્યો.
હવે કામ શા માટે તમારે નથી ચલાવવી પડી? એમ જ એટલે શું કામ? પૈસા મળ્યા છે? તો ધમકી આપી છે કોઈ? તો સમાધાન શું કામ કર્યું તમે? એટલે પણ શું કારણ તો હોય ને કઈ બેન, એમ કઈ કોર્ટમાં એવું ન ચાલે કે નથી ચલાવી. કઈ તમે કોર્ટમાં છો.
There is a no past antecedent only for 323.
Now since the complainant herself is waiting before the.
His father is present, I think. Her father has it.
The victim, if the victim is also ready to make a statement, since now there is some, the age that can be said is just 23. Any one victim that could be.
Father is here?
Yes. Our father is here.
Because she said she will use the word.
There is a no 326, 324, 325. Only for 323 is a bailable offense.
Don't argue on merit.
I'm sorry,
you
sir.
have to proceed. તમને પણ લાગેલું આ બનાવમાં? હવે તમને આ સમાધાન થાય તો વાંધો છે? કેમ હવે સમાધાન કરો છો? કોઈ ધમકી આપે છે? દબાણ છે કઈ? કઈ લાગે છે? બોલતા નથી તમે. સમાજનું દબાણ છે? નથી કઈ પૈસા મળ્યા તો ડરો છો કોઈથી તમે? કોણ છે આ તમને ગુનેગાર કોણ છે આમાં? બહુ માથા ભારે છે ત્યાં માણસો તમારા ઓળખીતા છે તો તમે સમાધાન એટલે કોણે કરાવ્યું આપને સમાધાન? કોણે કરાવ્યું સમાધાન? કોઈ કરાવ્યું હશે ને કે તમે જાતે જતા રહ્યા ત્યાં? કોણે સમાધાન કરાવ્યું તમારે? ભગોરા જ છે એ એટલે તમારા જ્ઞાતિના જ છે એટલે જ્ઞાતિ વાળા એ વચ્ચે પડીને સમાધાન કરાવ્યું કે એમને બીજા કોઈ કરાવ્યું? નથી ખ્યાલ તમને? તમને વકીલ સાહેબે કીધું એમ લખી દીધું એવું છે? ખરેખર સમાધાન થઈ ગયું છે? તમારે આગળ નથી ચલાવી ફરિયાદ? બરોબર છે, રદ થઈ જશે ફરિયાદ. તો તમે કોઈના દબાણથી કહો છો કે બીકના માર્યા રાખ્યો છો? તો કારણ શું સમાધાન કરવાનું? યસ, your IO is here. Considering the averments made in when the matter is called out, who is for the complainant? થોડું ડાઉટફુલ લાગે છે દબાણથી કર્યું હોય બરોબર નહીં એવું લાગે છે.
સાહેબ બંને એક જ કુટુંબી છે.
Don't want to be a party where the undue force is. તમે એસર્ટિંગ કર્યું છે કે સમાધાન સ્વેચ્છાએ થાય છે?
ના કરેલું છે
એફિડેવિટ નહીં, તમે જાણ્યું છે જાતે કે એ લોકો ઈચ્છાથી કરે છે સમાધાન કે દબાણથી કરે છે? બિંગ એ ઓફિસર ઓફ કોર્ટ તમારી એ ડ્યુટી છે ને કે ખાલી આવ્યા કોઈ પાર્ટી એટલે આપણે કરી દેવાના પૈસા મળે છે?
due to family intervention they are willing to
Intervention. Who has intervened?
their family members have mutually decided.
The present petition is filed. The affidavit is filed of one Monica Ben Devjibai Pagoda, original complainant. And તમારું નામ શું છે? દેવજીભાઈ Pagoda. Devjibai Pagoda, who is father of the complainant, is also present in the court. And they have submitted that if the complaint is quashed, they have no objection. Learned advocate.
AB Parma.
You are for the complainant?
Yes, on behalf of complainant.
What is your good name?
Bhavin Trivedi.
Bhavin Trivedi has also submitted that he has ascertained about the genuineness of the compromise. And he is satisfied that the compromise is arrived between the parties without any undue force or and parties have willingly entered into compromise. Considering the same, the affidavit is taken on record.
I'm obliged. Gratefully obliged.
બધામાં પેલામાં affidavit is taken on record. પેલામાં
I'm obliged.
ગ્રુપ મેટર પછી રીકો
Vijay Kumar
1072 120 120 80. when the matter is called out, learned advocates are not present. In the interest of justice, matter is to be listed. શનિવાર સુધી તો આપણે ટોપ ઓફ ધી બોર્ડ છે. શનિવારે તો રાખવી નથી ટોપ ઓફ ધી બોર્ડ કઈ. સોમવાર મંગળવારે હે ના 14 એટલું બધું નહીં. ચોથી ટોપ ઓફ ધી બોર્ડ, ફોર્થ ટોપ ઓફ ધી બોર્ડ.
Sorry, I appear in the cognate matters in the main matter of 107. 107. I appear in cognate matters. It's tagged with other matters.
112 to 118.
Yes, sir.
You are appearing
In some of the matters, not all, but
so Mr. Joshi is present. Other advocates are not present. Yes. No. Sí, આમાં 5 મિનિટ. 5 મિનિટ ટોપ ઓફ ધી બોર્ડ. જે એક છે ને હજી એક ગ્રુપ નથી. 40 થી 46 પઈ હતી, પછી 86 86 હતી અને 103 છે ને નિસર્ગશા વાળી લિસ્ટ નથી, નોટિફાઈ નથી કરી કઈ નહીં.
May permitted to withdraw upon instruction with the liberty to approach the concerned magistrate to file application in light of the order passed by the Honorable Apex Court in this matter, my lords.
When an advocate has tendered the copy of the order passed in transfer petition number, criminal number 338-348/2021 by Honorable Apex Court in matter of Ketan Kantilal Sheth versus State of Gujarat, dated 9/9/2022, and seeks permission to in view of this, he seeks permission to withdraw
With the liberty to
approach the trial court
magistrate
with the necessary prayers,
application for transfer
necessary application
for transfer of the proceeding.
for the transfer of the proceeding.
Oblige, my lords.
The prayer is accepted, petition is permitted to dispose of as withdrawn.
Please, my lords. Oblige.
Daily board serial number 8, Mr. Ankit Sir, learned to be.
This body was enforcement of the FIR.
Yes.
FIR, my lords. Filed under section 323, 504, 5062, 143, 147, and 149 of the IPC, my lords. Where 18A is the, my lords, FIR.
Yes. What is the status of trial?
Please.
Bottom of the board. If trial is commenced, then nothing survives.
Please.
Yes.
You may want Mr. Adi Thakur.
No. In second call, learned advocate is not present. This matter is first time listed on 9/3/2021 and listed on 5/4/2021, and thereafter matter is adjourn from time to time without issuance of notice. Today also, the advocate for petitioner is not present even in second court. It seems that lost the interest in proceeding with the petition, dismissed for want of prosecution.
Well, Mr. A.F. Timberlake, Mr. Vedas Vagela, Leonard Petty.
First time 6/4/2021. Charge sheet is fine. And learned advocate APP has produced a report received from Nizar Police Station dated 26/6/2023, where the charge sheet is also filed during pendency of the presentation. Otherwise, also it seems that petitioner has lost the interest in pursuing the remedy. And therefore dismissed for want of prosecution.
Mr. Maulik Seth, Leonard Petty.
First time 6/4/2021. And adjourned from time to time, no notice is issued. Lost interest, dismissed for want of prosecution.
Mr. Mehul Kurti, Leonard Petty.
July 2021.
Learned advocate, when the matter is called out, learned advocate, Mr. Supti is not present in even second call. Learned APP, Mr. Jaiswal, upon instruction, submits that the now charge sheet is filed. In view of this, the petition is becoming practice. Otherwise also, since the petitioner, advocate for petitioner not pursuing this petition, requires to be dismissed, accordingly dismissed.
15, Mr. Sion Toxin, Leonard Petty.
Second call, the learned advocate for petitioner is not present. The matter is state first time on 12/7/2021. Okay, petitioner continuation not remain present. It seems that he lost interest in pursuing the matter, accordingly dismissed for want of prosecution.
23, Mr. Chetan Pandya, Leonard Petty.
Lord, I'm requesting for some time on behalf of Mr. Pandya as he is engaged with the coordinate court.
What is matter about?
That matter is regarding GST matter. I'll have to.
Yes.
Sorry, Lord, I'm not aware of the matter.
Yes. What is it? So GST?
No. 833 में डाल दिया 32.
Yes.
The direction is he seeking to question certify the order dated 10/20/2020 as per the order in connection to filing of the petitioner with the officer petitioner statement. Now that order is seen.
So his submission is mandatory provisions of section 57 of the Criminal Procedure Code and the provisions of GST Act 69(2) is not complied with. That is main allegation.
I think that there is a.
That is a
I think that I am satisfied.
now on a later occasion also.
With regards to the maintainability or following the procedure, unless you have to I will assist that.
And one more aspect, where in a earlier occasion, by order dated 21/1/2021. This court has observed that the learned APP for the respondent state has submitted that the bail application being a criminal miscellaneous application number 1393 of 2021, preferred by applicant for releasing the applicant on bail is already pending before the court. That similar relief is sought. So I take instruction to that effect. If you are not having copy of order, then get it. That 21/1/2021,
In fact, I'll have to call the GSC.
bottom of the board. 445. In time, verify. Try to get whatever detail.
Mr. Ankit Saab.
FIR under section 406, 409, 420, 5062 of IPC and under section 3 of Gujarat Protection Interest and Depositors Act. Page number 13 is the FIR.
Yes.
On 14, my lords would find the petitioner's name second in the accused column, Chirag Bhai Urfe Akash Kanayalal Trivedi. FIR starts from page number 15. 1-5. One accused, my lords, Indrajit C, who was, my lords, the sole proprietor of one firm called MMS. He has duped the amount of the complainant and other, my lords, victims. Now, my lords, the FIR came to be filed against the total 5 accused, my lords. Since Indrajit C has died, my lords, this 5 has held liable, my lords.
Yes, what is charge sheet is filed? 2021, thereafter, matter, no notice, no interim protection.
By this time.
Verify 445, other matter is kept at 445.
Please, I'll give it.
445, give the
Please.
papers to the. We need some more assistance from your side, so at least
For example,
Sorry.
you don't have file, but kind of from status.
you can verify at least for first 70-80 meters in daily board and 40-50 meters in.
Follow.
Please.
For the English Copa Limacha relatively.
Second column, so the learned advocate for petitioner is not present. First time matter is listed on 15/7/2015. Thereafter, matter is adjourned from time to time. It seems that the petitioner lost interest in pursuing the remedy. Dismissed for want of procedure. Recall पति की 31 होगी. अच्छा मेंशन की कोई तो હજી એક થોડી આમાં 2-4 મીટર લઈએ ને પછી આગળ.
For continuous 45, which are office W.
Yes.
Actually requesting for give back.
Right.
Mr.
How now 330 meter can meter kept back or why? Which order you are challenging? Yes, 306. Here also charge sheet might be no interim protection. Only notice is issued. Who is appealing?
There is a order, passing interim order
Guwahati co-accused still. So far as this case is concerned, there is no interim order.
Only notice is issued. That is-
Notice of the phone not received, right? And let it get back. I'll verify that in this case also not that. Because in others, it appears no procedure to catch my not be right.
Here, there is no interim relief. Yes. Next. Charge sheet is fine,
No, my lord.
right?
The stay granted in the matter of co-accused, therefore it was ordered to be heard. It was said one occasion, there are three
Who
matters.
prevents them
But there are three
filing
matters
charge?
involved.
Whatever, whether any interim relief is granted,
So in this in my matter, it was notice was issued because the anticipatory bail was granted to me, therefore the notice was issued.
it's the request.
Let's call IO because in this case we might have.
So
taken,
14th, the co-accused application before this court is on 14th. 14th, no, 13760 of 2020.
Why I should keep this matter? voting?
Any day, any day.
Let the concerned investigating officer remain present with necessary papers. Released on 14th.
Officers, तिथं साडे सर्वांनी तिथं अर्धे गोष्ट तिथं सुधार केस काढून
Yes. The main matter I'm seeking some time, my lord. And some, there is the matter filed by Mr. Goswami is
3392.
33.
Main matter.
The main matter. I'm seeking. But they have no, absolutely no. He's my brother, my lord. He is seeking to implement proceedings under the Arms Act for which he has no connection. In fact, my lord, even in a prohibition case, when they sought to implicate themselves at the before the Honorable Apex Court, also they were then Honorable Apex imposed a cost upon them at the stage of bail. So that, but in the main matters, I'm seeking time. I'm not saying some short accommodation. There was an order of no court. There is, maybe they can give an update.
Why you are asking for time?
But there is this is a case where I had a license in my favor. And not the license expired on 1st of July 2020. Within 30 days, on 30th of July 2020, I applied for renewal of the license. But after that, in October 2020, I received a communication from the concerned authority giving a show cause like, why should this not be suspended on account of some cases filed? But there are cases essentially between brother dispute. There are many cases, etc. filed. I gave a reply, etc. to that. Pursuant that, I received no further intimation. So I presumed that chapter was closed. But despite that, I was advised safe side that since your renewal is still pending and there is no reply, you deposit your arms and ammunition. So I have in fact gone and deposited my license revolver, which I had since several decades before the police authorities. Pursuant that, it appears that some cartridge in the case of a search by the police in some incidental other prohibition offense, in my office, they said there are some cartridges found. For that, not the Arms Act. There is no revolver, there is no conscious possession, there is nothing. But the only aspect the reason I'm seeking is that there is an application made by me for renewal, which I am instructed possibly is under process. So I just want to take a sense because if that is allowed, then ultimately it will relate back to the date of the application. There will be nothing at all. To that extent, I may just take instruction. And as far as my learned friend is concerned, they have no locus. That can also be decided today. Otherwise, they are my real brother, my lord. They are seeking to implicate themselves in this by saying
I should invest.
Very well,
more
I'll assist the honorable
Let it
court.
be some other day.
Please.
8 August.
Please. IR may be extended.
Interim relief.
I'm obliged.
Officer Mr. Gopal Vyas, Mr. Vishnu Mulkan.
Offense is under the 498, Lordship 23. Present British.
Charge sheet is filed.
No, Lordship. Even otherwise, all of these are acquitted, Lordship. This is the order of
All accused,
all, except this.
including present petitioner.
No, no, no.
Because here this protected.
Protection. Your husband?
No, no, Jait and Ajit. Even husband is acquitted.
Yes. Notice is served.
Yes.
Yeah, that's the file.
Who is appealing?
Let it be passed over.
Evan Simankan. The bottom of the board, 445. We pass over. પચાસ સુધી આના પછી નેક્સ્ટ કરી દો. યસ પછી 50 સુધી લેજો પછી રેકોર્ડ કરી દઈશ.
Offense under section 406/420, my lord. After more than 10 years, the FIR has been reached. Allegation in the FIR that the complainant had purchased different piece of land from various vendors, my lord. The page number 17, my lord. The allegation against the present applicant and her mother. Mother is expired, my lord. Accused number 8 is expired. 9 is the present applicant. Only last para of the page 17, that is the allegation.
Page
17.
yes.
તેમજ આ જ દિવસે 24/5/2010 ના રોજ મલેક બીજબાઈ મલેક જીવાબાઈ બંને રહે જેજરી વાળાઓની જેજરી તાલુકો પાટડી જિલ્લો સુરેન્દ્રનગરના સીમ સર્વે નંબર 104 વાળી જમીન રૂપિયા 1 લાખ પુરાનો દસ્તાવેજ મારા નામનો કરાવી ખરીદ કરેલ. આ જમીન ઉપર આ જ સર્વે નંબર વાળી જમીન ઉપર આ લોકોએ મારા નામે સહી કરીને મારું નામ 7/12 માં તેમજ અન્ય દસ્તાવેજમાં નહીં ચડાવવા દઈ ઉપર મંડળી તેમજ બેંક થી લઈ બોજો ચડાવેલ છે. Lordships may kindly see the entry page 35. We had never created lien on that land, Lord, but the entry which was mutated in year 2011 for different reason I had not opposed that entry, my lord. Page 35. નોટિસ મોકલેલ છે, વાંધો રજૂ નથી, દસ્તાવેજમાં 7/12 મુજબના નામ ચાલતા ન હોય. My brother who was expired unmarried, my lord. Therefore only 2 heirs, my mother and present applicant, were the owner of the land. In 1996 the Rahim Bhai, who was the brother of the present applicant, was expired. The death certificate is at page 33A, my lord. Therefore this applicant and her mother both were the owner at the time of selling the land. Even the land was fragment, my lord. That was the one reason. Thereafter, my lord, in 2012, my lord, he had also further attempted to mutate the entry, my lord. Page 36, my lord. I had not opposed any entry, my lord. That also, my lord, was cancelled. Thereafter, my lord, again in 2015, my lord, we had not opposed, my lord. No any documentary evidence to show that I had created any lien upon the land, my lord. Even he had not raised any appeal against these entries, my lord. No civil suit is filed, my lord. After more than 10 years, false allegation, my lord, that I have created lien and 7/12 માં નામ નહીં ચડાવવા દઈ. There was no any fault on my part.
Why you have not raised any objection?
Because, my lord, I had sold the property, my lord. I have not objected entry, but as per the case of prosecution, my lord, they had page 17, which I read, my lord, that they have created lien, my lord. But in the entry, there is no any words, my lord.
Page 18.
Yes, my lord.
Second paragraph.
Yes. તેમજ આજ દિવસે 100 ના સીમ સર્વે નંબર વાળી મારા નામનો દસ્તાવેજ, આ દસ્તાવેજ કરાવ્યા બાદ આ લોકોએ ઉપર મુજબની નોટિસમાં સહી નહીં કરી. This is of different person. તેમજ આજ દિવસે 100 ના જેજરી પાટડીના સીમ સર્વે નંબર 384 જૂનો 118 વાળી ખેતીની જમીનના દસ્તાવેજમાં રાયબજી રાયસંગજી મલેક નાવે રૂપિયા 100 ચૂકવીને મારા નામનો કરાવેલ. આ દસ્તાવેજ કરાવ્યા બાદ આ રાયબજી રાયસંગ મલેક નાવ 135 ની નોટિસમાં સહી નહીં કરી આપેલ અને મારું નામ 7/12 માં તેમજ અન્ય દસ્તાવેજમાં નહીં ચડાવવા દીધેલ. He is also accused. 15 persons are the accused persons. So far as other persons,
bank loan line,
they might have, my lord, but in my case, my lord, he have raised a common FIR, my lord. So far as allegation against me is at page, last para of page 17, my lord. Child is also produced.
You are original owner.
Honor me.
Where is cell it?
Yes. Page 20.
Lekha Ileana,
Yes.
Imanshu,
Yes.
Malek Bizbhai.
Yes.
So who is complaining?
Complainant is Varia Himanshu Bhai, who is not representing here also. So notice is served.
So who are you?
I am the original owner, one of the owner. Bij
Who
Bhai.
has sold the
Yes.
property
Bij Bhai
to the-
is Bij Bhai is the my mother who has expired, my lord. Now Malek Jiva Bhai is the present applicant, my lord. I and my mother both had sold the property. We have never denied that we had not sold the property. But so far as the reason stated in the entry, my lord, the entry could not be certified. And the transaction was, my lord, taken place in 2010. The FIR is raised in 2020, my lord.
If you have sold the land, then why you have not signed the 135D notice?
It is not the case, my lord.
That is the case.
It is for other persons, my lord, other accused persons.
So how other accused person is?
Yes, my lord, page 30.
If you have sold the land, how other accused person can?
They have sold the other land, my lord. This is not my land. He has raised common FIR, my lord, of many part of land, my lord. Various transactions were taken place, my lord. So far as I am concerned, allegation is at page
Matter
17.
of trial, Mister.
But this is clear case of abuse of process of law, my lord.
How it can?
Yes, my lord.
Merely using word abuse of process of law, you have to establish that.
But they have to prima facie establish.
On the
Even
contrary,
he is not representing
from the-
before this honorable court, my lord.
from the government, it transpires that there
But
is some
see, and
role is played by.
the
You are deliberately
no, my lord, not deliberately.
connived
Even
with,
as on today, I am ready.
some other persons have misused this document.
No, my lord, this is not the
And
case that
availed
I had
them.
signed. This is not the case of fabrication or
That
any
is the
other.
reason that you have not accepted this notice.
We
of
have
135.
accepted, my lord. We વાંધો રજૂ નથી, my lord. Page 35. Page 35, my lord. Annexer E. Notice મોકલેલ છે, વાંધો રજૂ નથી. We had not opposed that entry, my lord. But why?
LLJ is a different thing. Accept karo is different હોય ને.
બીજામાં પણ વાંધો રજૂ નથી.
It's a matter of trial.
No, my
You
lord,
have
this
to-
is the
you-
case of even after 10 years, my lord.
That is the person who came to know about the such.
He
fraud or
was very well aware, my lord, in year 2011 that the entry is not certified, my lord. Thereafter year 2012, my lord. Thereafter year 2015. And this is not the case that I had opposed the entry. But it was fragment, my lord.
The fragment.
It was for fragment. Therefore, it was.
Then how the cell deed is executed? If it is fragmented,
Yes.
whether
It
cell
could
deed
not
can
have
be
been.
executed?
But my lord, we have not opposed the entry. Even as on today, we are not opposing. Even he has not raised any appeal, my lord. Not filed any civil suit. And this is not the case that he was hindered. Possession is with me, my lord. That is not the case.
Yes, what is your instruction, Mr.?
It is not.
Because stay is being
Sir.
operated.
Stay.
Yes,
of
stay.
Filing of charge sheet?
No, my lord. No.
No coercive action.
Yes, no coercion. Charge sheet, yes. Whether charge sheet is filed, no coercive action.
If the application is, see, this page number 60.
Yes.
It says that there are about 15 persons who are available. As far as the present applicant is concerned, you already has accused number 9.
Yes.
You have to add on to it. Now, with regards to the same deed, which is annexed, Investment analysis date 24 of the same paragraph 2 net analysis. The governments made in the same paragraph 2 net analysis.
Yes.
That the government can do. That lucky आपने in the date में तो पता हमें भी अपना मंदिर भाई पता केवल गाड़ी गैस और वो जलता दाने हमें लकी अपना रहने दुनिया कराता है ये हमारी
Yes.
अन्य कोई बात है and can we see another class don't with their page 35 we have 6
Yes.
where my friend says notice me मुख्य છે પાંડો રઘુનાથનું દસ્તાવેજમાં દર્શાવેલ મુજબ સાતવારના નામ ચાલતા ના તેથી વેચાણનો ટુકડો થાય તો નેક્સ્ટ પેજ 36
Yes.
But application that entry was cancelled it is mentioned as but thereafter the endorsement will kindly notice was in page 36
Notice for jewelry, yes.
દસ્તાવેજોમાં દર્શાવેલ મુજબ સાતવારનું નામ ચાલતા ના હોય તથા વેચાણ સમ ટુકડો પડતો હોય. And page 36
No, my lord, I have stated in the cell deed itself કે so and so ગુજરી ગયેલ છે અમારા પુત્ર. And page 33A is the death certificate, my lord. Everything is clear, my lord. He was well aware that Rahim Khan is already expired and
Thereafter, the investigation is further carried out and there is some material are available against
but
it.
this is the material, my lord. Except this, nothing would be come on record, my lord. Because the Rahim Khan was expired as unmarried, my lord. Therefore, the mother and present applicant was only the heir.
Face the trial.
This is the clear case. After 10 years, my lord, even thrice he had attempted to made the entry, my lord, which could not be certified on other reason. And he is stating that I have created the lien. There is no any documentary evidence to show, my lord. Even he has not represented before this honorable court. He know everywhere that it is stated in the cell deed also, my lord, કે રહીમ ખાન ગુજરી ગયેલ છે અમારા સિવાય કોઈ વારસદાર નથી.
Your cell deed is executed on which date?
Yes, my lord, in 2010, my lord.
24/5/2010.
Yes, my lord. May 2010. 25th May 2010. He raised FIR after 10 years.
સર્વે નંબર 382 તથા 386 તથા 351
No,
તથા
here the
382
cell deed is of my
અંગેના
side.
7/12 બોલતા બેંકોના બોજા બાબતે શ્રી સેવા સહકારી મંડળી ખેરવા તેમજ સિન્ડિકેટ બેંક સુરેન્દ્રનગર ખાતે જઈ આ બાબતે તપાસ કરતા સદરુ સર્વે નંબર વાળી જમીનોમાં પડેલા બોજા દસ્તાવેજ કર્યા પહેલાનો હોવાય જો જણાઈ આવેલ છે તેમજ શ્રી સેવા સહકારી મંડળી ખેરવાનો બોજો ભરાઈ ગયેલો પરંતુ બોજો ભરાયા કોઈ નોંધ જમીન માલક તરફથી કરાવેલ ના હોય મંડળીમાંથી બોજો ભર્યા હોવાની દાખલો મેળવેલ ના હોવાના કારણે બોજો બોલતો હોવાનો તપાસ તેમજ સર્વે નંબર 382 તમારી
This is my
382 વાળી છે ને?
104 million. 104. 104 million. And only one survey number. So far as I am concerned. Though other persons might have committed that, my lord, they might have created lien, my lord. But so far as I am concerned, on survey number 104, my lord.
સાત બારમાં 3 વ્યક્તિ છે ને વેચનાર
But
2
it
છે.
is stated in the cell deed કે રહીમ ખાન ગુજરી ગયા છે અમારા સિવાય કોઈ વારસદાર નથી અપરિણીત છે. And page 33, my lord, 33A, 33. This is the death certificate of Rahim Khan. It was expired in 1995, my lord.
Call for the report from the IO.
Yeah.
Learned PP may call for the report for the IO about the present status of the investigation.
IR is there.
They were extended till next date of hearing. released this matter on 21st July.
How like?
Yes, 50 Karim Bashir, especially notified.
Yes. Under the section 5062 and 11 for initially lordships, but now the charge sheet is filed, I need to amend. Sahib, I know my lord's view, but only one thing. If my lords may kindly peruse the FIR for 1 minute, lordships. Only 506114 in the FIR. Absolutely political rivalry. It is incident is of 16th of February 2021. FIR on 17th of February 2021. One day, but sir, sir, absolutely, it is a political vendetta, political dispute between the.
I don't want to open the floodgates.
On sir, Amar sir, if there is nothing except making a gesture, allegation is only of.
Press petition.
Sir, खाली एक gesture is करो, that is what is alleged in the FIR. Only a gesture के सब गला पर हाथ फिरने को I'll just sir, only for a minute, if my lord must see page 14 lordships, last 4 lines. બે આંગળીથી ઊંચી કરી હાથ વડે ઈશારા કરી મારવાને ધમકી આપેલ. This is what alleged in the FIR lordships. And absolutely, he says it was a political gathering in a political party's office, and this incident took place. Therefore, I'm requesting that I may be at least permitted to amend and place charge sheet on record.
Yes.
I am having the
Yes,
amendment.
Mr. Mirza, matter is adjourned to.
I am having the amendment. If my lords may kindly, I'll file in the department. Please, lords.
The matter is adjourned to 27th.
Please, lords.
The rest of the matters after 50 daily board is separately notified. First, yes,
Petition is for the purpose of granting remission to the petitioner. He has completed 18 years and 18 and a half years of actual sentence, 23 years in total.
yes.
The application was mainly not considered on the ground that the state government is not an appropriate authority. However, to my instructions, what I could gather from online, the Honorable Apex Court had directed the state government to consider the case. This is the copy of the order. In view of the prevailing policy at the relevant point of time. It was directed that within a period of 4 months, the same should be considered. However, the same was not considered and therefore contempt petition was preferred. The online status shows that contempt petition is pending and these are the 2 orders that are passed. And the matter is kept on 7th of August 2023.
What is your prayer in the present petition?
To grant remission and to my prayer is at page 17.
Four 33.
Yes. Please, if one of the public tender the copy of the incident taken by the state government. It appears that when the Honorable Tax Court issued notice on the same, the very date was passed, therefore perhaps the council appearing, or matters it may not avail to the learned council appearing before the Honorable Apex Court. So if my lord there is a decision, it is dated 10/5/2023, and it was communicated to the jail authority as well as to the petitioner. There is a signature also, my lord. In the month of May 23-24, May 23, the order in the value, it is in view of the order passed by Honorable Apex Court. The Vanchan detail is the order of the Honorable Apex Court. And as Honorable Apex Court considered observed, that it has to be considered in light of the earlier policy. But that is the policy of 9/7/1992. If my lords may have first paragraph, 6th line, where it was observed. તે અંગેની અરજી પણ વિભાગના તારીખ 9/7/92 ની નીતિ મુજબ સંબંધિત જિલ્લા પોલીસ અધિક્ષક જિલ્લા મેજિસ્ટ્રેટ અને સજા કરનાર કોર્ટ ઇન્સ્યોરન્સ ઓફિસર મેળવવા આવ્યા હતા તે ગુનાની ગંભીરતાને ધ્યાને લઈ આ કેસ તપાસ કેન્દ્રીય તપાસ એજન્સી સીબીઆઈ દ્વારા થયેલ હોવાથી CBI નો પણ કારણનો સહિતનો અભિપ્રાય મેળવવામાં આવેલ હતો તે નીચે મુજબ છે. મને this are the opinions which have been taken and my lord second page is my lord reduced the reason for rejection. કેદીની વહેલી જેલ મુક્તિ બાબત સંબંધિત સત્તાધિકારીશ્રીના ઉપર મુજબના અભિપ્રાયો ધ્યાને લઈ કેદીની વહેલી જેલ મુક્તિ અંગે જિલ્લા જેલ સલાહકાર સમિતિ બેઠક 12/1/23 રોજ આયોજિત થયેલ, જેમાં ગુનાની ગંભીરતા, સ્વયંતો અપરાધ, ઠંડા કલેજે કરેલ હત્યા તથા કેદીની CRPC કલમ 433 અન્વયે વહેલી જેલ મુક્તિ માટે સંબંધિત ઓથોરિટીના નકારાત્મક અભિપ્રાય ધ્યાને લઈ સમિતિમાં હાજર તમામ સભ્યો દ્વારા સર્વાનુમતે કેદીનો વહેલી જેલ મુક્તિ અંગે નકારાત્મક અભિપ્રાય આપવામાં આવેલ છે. After considering that, madam, કેદીને અપહરણ અને પૂર્વ આયોજિત ઠંડે કલેજે હત્યા કરવાનો ગંભીર અને ધન્ય પ્રકારનો ગુનો કરેલ છે, જેને અવલોકનમાં લઈને કેદીની વહેલી જેલ મુક્તિ બાબત પોલીસ અધિક્ષક શ્રી CBI ઓફિસ મુંબઈ જિલ્લા જેલ સલાહકાર સમિતિ તેમજ અધિક પોલીસ મહાનિર્દેશક અને જેલના ઇન્સ્પેક્ટર જનરલની દ્વારા નકારાત્મક અભિપ્રાય આપેલ હોય. It was rejected. Therefore, this petition is
Are you provided with the copy of this order so that I can take appropriate instruction? Because it is not even filed before the Honorable Supreme Court. In considering the date of the order, the Honorable Court may kindly see these two orders. When the order is passed and the manner in which the order is. The Honorable Apex Court directs in the month of September that you consider within a period of 4 months. Nothing is done. I prefer contempt petition
Arising from same proceeding.
from the same proceeding. It is not from the, it's from the same proceedings, contempt. The first order, the court issues notice making it return. First order is dated 24 April 2023. The matter is posted on 12/5/2023. And the teeth of those proceedings, only because the petitioner preferred a contempt petition, on the very same day an order is passed stating that we are rejecting it. And no copies preferred. No copies neither provided in this petition nor before the Honorable.
Now, the concerned advocate might receive, but the copy was served to the concerned petitioner. The endorsement.
It
It was after.
I may be provided a copy. I may take appropriate instructions.
Even if my learned kind of stated that honorable effect could also kind of create the same issue. Why is there better pending?
It is under contempt, not on the same issue. Therefore, if the order is not as per the policy or the consideration is not given, malafidely it is the order is passed only with a view to frustrate this proceedings as well as the proceedings before the Honorable Apex Court, my petition would still survive. Well, the matter was kept on 12th, on 12th, we are passing an order informing the Supreme Court. That's why we are passing.
2 days prior, 10th of May, not on 15th.
So what do you want?
May I request for next week, I may take instruction and a copy will be provided.
I'll give my copy.
Xerox કરાવી નાખજો ને તમારી પાસે નહીં. Please the request of learned advocate Mr. But to take further instruction in view of the subsequent development. Matter is adjourned to next week is not possible. Any date after 20 Velamveli ક્યારે? જુલાઈમાં Velamveli 28.
Please.
Yes, Mr. Dave.
Is this a matter for infusing a unwanted remarks, Lordship? Here I am a district superintendent and divisional superintendent, police superintendent.
Why?
In one bail application, the presiding officer feels that instead with 409, you should invoke the provision under the corruption. But IOS says that it is not possible at this stage, but we will incorporate at the time of filing the charge sheet. Then rejecting the anticipatory bail application, they have remarks against me and my divisional supervising officer. I have no role with entire. I am not the investigation officer. Nothing is.
Why a remark is made against you?
Yes, because.
Where is that?
Yes, remarks is at page number mm, he said that though we have informed, even though the offense under the Prevention of Corruption Act not incorporate, that's why. Page number 64, 63, Sahib start થાય. Even an investigation officer said that the allegation is against the in a department of postal department. If we invoke even a corruption act, then we need to take a sanction. Then also this investigation will not even lies without even that will be goes with the CBI. And the allegation is that 19,000 rupees misappropriation. There is no allegation even for a corruption, lordship. Page number 63, para 10. વધુમાં નામદાર સુપ્રીમ કોર્ટ તથા નામદાર ગુજરાત હાઈકોર્ટનો ઉપરોક્ત ચુકાદા તેમજ અગાઉ પ્રસ્થાપિત કરેલ સિદ્ધાંત મુજબ કાયદાની પરિસ્થિતિ બિલકુલ સ્પષ્ટ હોવા છતાં આરોપી વિરુદ્ધના ગુનામાં આ કામના પીસી એક્ટની કલમ 13(1)(1)(c) મુજબનો ગુનો બનતો હોવા છતાં અને પીસી એક્ટ તે સ્પેશિયલ એક્ટ હોવા છતાં વધુમાં સ્પેશિયલ એક્ટ અન્વયે જે આરોપી વિરુદ્ધ પીસી એક્ટની કલમ અન્વયે ગુનો નોંધવામાં આવે તેવા આરોપીની મિલકતને એટેચમેન્ટ લેવા સંબંધે ક્રિમિનલ એમેન્ડમેન્ટ એક્ટથી સિવિલ કાયદામાં જે રીતે મનાઈ હુકમ આપવાની જોગવાઈ છે તે જ રીતની જોગવાઈ થયેલ હોવા છતાં તે મુજબ તપાસ અધિકારી આરોપી વિરુદ્ધ સ્પેશિયલ કાયદાની જોગવાઈ મુજબ અસરકારક કાર્યવાહી કરી શકે તેમ હોવા છતાં આ ગુનાના કામમાં કોઈ પણ અગમ્ય કારણોસર તથા અવાંતર હેતુસર વિભાગીય પોલીસ અધિકારી અને જિલ્લા પોલીસ અધિકારી આ ગુનાની તપાસમાં બિનજરૂરી હસ્તક્ષેપ કરી રહેલ છે અને તે વ્યાજબી ન કહેવાય. વધુમાં જિલ્લા પોલીસ અધિકારી અને વિભાગીય પોલીસ અધિકારી જેવા ઉચ્ચ હોદ્દો ધરાવતા અધિકારીની ફરજ આરોપી વિરુદ્ધ તેણે કરેલ ગુનાના સંબંધે કાયદા મુજબની અને તે પણ સરકારી નાણાંના ભ્રષ્ટાચારના ગુના સંબંધે આરોપ સંબંધ જે પણ કઈ જોગવાઈ ઉપલબ્ધ હોય તે અન્વયે પ્રમાણિક અને નિષ્ઠાપૂર્વક સખતમાં સખ્ત કાર્યવાહી કરવાની હોય અને તેઓને સરકારી કર્મચારી તરીકે સરકારી ફરજ બનતી હોય તેમ છતાં તેઓ આ કામના તત્કાલિક અધિકારી જે તપાસ કરી રહે તેમાં સ્પષ્ટ રીતે બિનજરૂરી હસ્તક્ષેપ કોઈ પણ જાતના વ્યાજબી કારણ વગર કરી રહેલ છે. There is no such how they came to know that. There is no such even an investigation. Lordship may see the affidavit of the investigation officer. Investigation officer is stated that page number, it is start from page number 28 and it is ends with the page number 37. He stated that he took the opinion of the district government leader, everything. Then he came to a conclusion that charge sheet will be filed but at this stage, because it is anticipatory bail, this stage is not deemed fit to add the section 13, lordship. There is no reference
so
that
many judgments are produced along with the
yes,
petition.
in these cases also, this same presiding officer is remarks against the other officer also.
So he is not giving different.
No, I am not saying that, but I am not saying that, but at least some material
He
against.
is found that something is required to be observed. What is wrong in it?
But at least there is some material against me. In entire bail application, if there is a material against me that I have anyway interfere in investigation or I am I have tried to escape the accused.
Something is required to be presumed.
409 is a
Presumption is not available.
no, 409 in that the punishment is up to life, and under the Corruption Act the punishment is up to 5 years.
Yes, yes.
Investigation officer in investigate offense under 409, there is a greater punishment than the and there is no reference that I have anyway even said that no, you should not carry out the, even investigation officer is stated that he taken an opinion of the district government leader also. What they can do else, lordship?
You have drafted this petition?
No.
Yes. Yes.
So from the online status, it appears that it is CBI case not 17. The present proceedings, no notice have been issued. And the challenge is that the order passed by London trial court consent below. Common notice, I would doubt whether it can get a notice also or not. But investigation by that might be carried out by CBI officer. Therefore, it will not.
No, he is asking for some
Of remarks made by-
some remarks made in the you are not having papers, then you just go through it. We'll keep this on some other day. Otherwise, I'm looking to the present scenario, his remarks is correct, but not correct. Not warranted. That the matter may be learned APP may assist the court. You are having papers or he will, the learned advocate for the petitioner shall supply the entire set to the learned APP to, with a view to assist the court about the further proceeding in view of the amendments made in the petition. Release this matter on 28. Yes. 2nd August.
I'm withdrawing this petition.
Withdrawing. Learned advocate Mr. Anjaria on behalf of Mr. Nigatpuch seeks permission to withdraw this upon instruction from client. Permission is.
This court is not gone into merits.
Court has not opined anything on merits.
Deeply obliged.
On behalf of Mr. Sanat Pandya, we are to withdraw from the matter and NOC has been given.
It is not ground to adjourn the matter. He has to file appropriate note as per the High Court rules. Yes, what is matter?
Caution FIR.
Atrocities. Yes. He is not interested to pursue learned advocate so and so on behalf of learned advocate Sanat Pandya. 6 time to file appropriate note to for withdrawal of appearance. Let the note shall be filed after following due process within a week from today. Thereafter, registry may list this matter thereafter.
Number 5, Mr. Dayfresh Rewala, Mr. Anik Kandi.
Yes.
So the FIR is at page 60. It is filed after 4 years. I see no explanation for that.
No explanation.
No explanation. And everyone is roped in. Purely business transaction. What will see offenses under 406, 409, 420, 504,
Any civil proceedings, sir?
No civil proceedings. ને કેટલા બધા પૈસા આપ્યા sir? Out of the monies due, there we have put whole records of the monies that we have paid, including bank receipts. This is totally abuse.
Where is Mr. Kadri? Who is appealing?
Number
26 onwards. 26 table.
So 26 is the table.
Yes, yes.
I have paid him 2 crores 8,44,626. Those substantial amounts admittedly are not paid also. I was a very successful businessman. I tried doing business when China and India had good relations in that country. And then the relations soured and he has hit very bad times. That is why, even though many times we have tried for settlement also, he has no money to give. That is the fact of the matter.
So at present, what is position?
Sir, I have only no coercive action for this man.
No. What about that
They can
repayment
investigate. There
aspect?
is no problem.
Repayment aspect?
I can't take it. That's the fact. I have made it clear before the formal court. But these are purely civil disputes, sir. And the petitioner, complainant has come page 17 on his
Yes,
behalf
where
and
is
on behalf of
complainant? Who is
Complainant
appealing
not
for?
now, sir. If the settlement is interested, otherwise they be to the court ma jaine શું કરે?
Let him. On any other day. Short date of the day. Second or third week mark. नहीं जुलाई में क्या थर्ड वीक में क्या मैच
27.
Lordship.
Relief country.
The relief may continue.
Yes.
And now it may not be limited because no,
unlimited
I'll leave it.
till further road.
Obliged.
Next, Mr. Mahdi Wagera, Mr. Bhavesh Chaudhary. Gujarat Butch.
Yes.
Plus the offense under section 406, 420, plus 465, plus so far as the present applicants are concerned, plus they are original accused number 8 to 11, plus page 15 is the FR, plus the applicants are purchasers of the land in question by registered seller. Plus page allegation with respect to the present applicants, plus page 17 if the honorable court may kindly say. Plus accept the name, plus there is nothing against, plus so far as the present applicants is. Plus
Page.
complaint, plus page 17 is the FR, Millers. In fact, it starts from Millers page 16, Millers. Millers
Yes.
complaint is filed
Any
against
requests?
Monday.
Monday, right? So what is status of the matter?
Plus in fact charge sheet is filed. Millers.
Charge sheet is filed
Charge sheet, Millers, I have annexed the charge sheet papers.
during pendency or prior to?
Millers, in fact, at the time of filing, Millers, the charge sheet, I'm sorry, subsequently Millers charge sheet was filed and thereafter amendment application came to be moved.
Allowed.
It was granted and Millers, the charge sheet papers are there.
A report of this.
Yes. What is stage of trial?
Recently filed March 22. This pending will run it for.
Let it be on some other day. He is
Any-
requesting. Learned advocate, you are for complaint?
Yes, my lord.
Mr. Anjaria, on behalf of Nirad Butch,
Yes.
praise for time. Learned APP, Mr. Jaiswal has tendered the report received from Police Inspector Kamaraj Police Station. With date, date of report to be inferred. એવું?
I'll give the date.
આજે આપ્યું એટલે આજે. Ask your officers at least to prepare a report in appropriate manner.
Next date.
આપો ને એમને લખી દેશે date. If your officer is present, give the
Please.
date of today. In view of this, ક્યારે રાખશું? first, third August.
Please.
Yes, Mr. Anjiola. No, except adjournment, make appropriate. Yes, every day on one count or another matter is required. to be adjourned. We need the cooperation from the and with at least in this sitting, I found that at least from your office, I am not receiving cooperation. Why you are not? Then I will say that no, not before me. Every matter you can, if you are not comfortable with this.
Today the difficulty is health, short accommodation in this.
What is matter about?
Not acquainted with the type.
You are not aware. Yes, what is matter about?
But I received a letter from also. That is what is filed.
Your city is fine.
On record, it is not showing now, but it's
The interim relief is granted, but is
no courses.
no courses.
There is an complaint. Ushaben's letter given to officer government leader. So everything is certain contention against the petition.
Take instruction.
I'll let that call down.
Learned advocate Mr. Anjiwal prays for time as a last chance matter is adjourned to 1st of July. Why I should extend the interim relief? If you are not ready to
Proceed on time.
interim relief extend.
I was in charge of a fair price shop. Now allegation is that they have raided this shop at the relevant time and found some this ration shop was raided. It was found that the material was not there of the which tally with the register. Now I have given several representations and also raised contention that it is in other godown because of rain. There was a problem with this godown. I also had photographs which were sent to them that this was in the other godown, that material. Kindly see the FIR, page 13, page 12. It is by a supply officer. Collector Sahib Banaskantha na hukam number so and so 17/2018 થી સંચાલક લાખણી સામે નીચેના કારણસર ફરિયાદ દાખલ કરવા અમોને અધિકૃત કરવામાં આવેલ છે, જેનો નીચેની ફરિયાદ આપીએ છીએ. માનનીય કલેક્ટર સાહેબ શ્રી તરફથી ટેલિફોનિક સૂચના અન્વયે 14/2018 ના રોજ દિયોદર દેખરેખ હેઠળ અમો મામલતદાર શ્રી લાખણી સોએનસોની સંયુક્ત ટીમ દ્વારા 17:30 વાગે શ્રી MC ચાવડા સંચાલક શ્રી
Raid is carried out on 14/3/2008.
Yes, FIR
માર્ચમાં ક્યાં વરસાદ હોય છે? Rainy
ના
season.
સાહેબ એ પહેલા જે ગોડાઉન માં રાખતા હતા ત્યાં ભેજ હતો એટલે સાહેબ એવું એને રિપ્રેઝન્ટેશન માં કીધું માર્ચમાં રેની સીઝન ની but it may expect that rain but સાહેબ it was there. The only technical issue is that I moved this. It is not that
is a substantial.
But then under 3 and 7 I can be prosecuted, not 409, which is aggravated form of criminal breach of trust.
You can file the appropriate application for discharge.
Because I am not sure whether charge sheet is filed or not, because no coercive action.
No coercive. Normally they are not filing charge sheet where the no coercive. The interpretation is that when the no coercive, no charge sheet. Because you are not arrested. So
My learned friend is
obviously
probably my instruction are probably charge sheet is filed in this case.
Then also in that case also you.
In that case, I will not invite. But if charge sheet is not filed, I may try to.
Your instruction is perfect.
No,
Normally-
my learned friend may
Yes,
confirm. They are.
Yes, yes.
He was not called after charge sheet. Therefore,
445. 445.
Luckily, we have all the statements. Investigation was carried out. Only the aspect of charge sheets of filing is not done. because of no court.
Practically, is a charge sheet is now filed.
To the statements.
Otherwise, also, I am not inclined.
Lordship, only one part of 409 if it is seen,
Appropriate, I will keep.
because 409 Milord provides for life. Sir, generally under essential commodity, they adjudicate first under section 6A, Milord, and then 6B proceedings are undertaken, and then Milord, straightway FIR under, because my representation says.
You can file a discharge application. Who prevents it?
But I will be arrested. That is the difficulty. I'll have to, because charge sheet, if it would file some
Something
protection.
is required.
They have already recorded statement, Milord. If it can, they can file charge sheet, Milord. There is, I can.
They
Not-
will do that. Ask your officer to do it.
They have already recorded all necessary. If
Yes,
my custody is not required, Milord, then they can consider
Yes,
filing
that
of
is a-
charge sheet.
Otherwise, they will.
For filing of charge sheet, they may not require my arrest. That is what I am trying to say, Milord. Because it's a 2018, after 5 years have passed, and till 5 years I have been protected. Now, if that is investigation is over, Milord, they can file charge sheet. I may not press on that ground.
Much water has passed.
Yes, so 5-6 years, Milord, after 5-6 years. Now I have also changed my stance from X party to Y party. Milord, this is local politics. I have given my representation. Milord, that is also not taken care of, Milord. Initially, because of Sarpanch election, Milord, I have alleged that something has happened. But anyways, Milord, I will not press without going into merits, and some protection, Milord, with regard to charge sheet, because they are saying that they are ready with the charge sheet.
Yes, that if they will, you are managing you are in politics. So
I was, Milord. Now,
yes,
after FIR, I am not sure whether he is there or not in politics.
then advocate Mr. Popat. Seek permission to withdraw with a view to avail appropriate remedy. And this court will not examine the very matter on merits.
Lodge.
Permission is granted. Disposal.
Lodge. If investigation is concluded, that can be, if my lord.
Yes, it is open for the prosecute, since learned APP has submitted that the investigation is almost over. Let the charge sheet may be filed as expeditiously as possible.
Lodge.
My Mr. Bhavid Rajani, Mr. Yunis Malik.
Here, my lord, the offense under section, my lord, the 376, 323, 504, 506, and atrocity. Now, my lord, kindly see the FIR. The FIR is registered against the present petitioner after, my lord, the 3 years. As per the FIR, as well as I have the documents that between the complainant and the present petitioner performed the marriage in 2014. Kindly see.
Yes.
And after 2014, in 2018, my lord, the complainant said that
Read page 12, bottom.
Yes. One.
Last few lines. Rutik Shah and Sanjay Gora Besta, judge. Page 12.
Page 12. But may I read, my lord, only? Yes.
Bottom.
Only the FIR, my lord, the 2011. It is mentioned that the સને 2011 ના વર્ષમાં બોરસદ મામલા
2018 FIR.
Yes, 18 FIR, પણ સાહેબ એમને જે FIR નું
Now 2014-15 એને હિસ્ટ્રી આખી આપી છે.
સાહેબ 2014
15 2015 માં માર્ચ એપ્રિલ
સાહેબ
માં
I'm sorry. Yes, the 2011 થી હિસ્ટ્રી આપેલી છે. ના 2011 થી હિસ્ટ્રી આપેલી છે. In 2011 yes,
જે બંને જણાએ મારે હતા
ના એક ખાલી
પછી આગળ વધ આપણે
સને 2014 માં રાજુભાઈ ચંદુભાઈ પરમારનો રેશન કાર્ડ નો કોન્ટ્રાક્ટ પૂરો થઈ ગયેલો,
જેથી હું રાજુભાઈ ચંદુભાઈ પરમારને બંને જણાને બોરસદ મામલતદાર કચેરીએ પુરવઠા વિભાગમાં કોમ્પ્યુટર ઉપર બેસી ફોટો ફિંગરિંગ લેવાનું કામ કરતા હતા. ત્યારબાદ સને 2015 માર્ચ અથવા તો એપ્રિલ રાજુભાઈ ચંદુભાઈ પરમારને સ્માર્ટ ચૂંટણી કાર્ડનો કોન્ટ્રાક્ટ મળેલો. તે દરમિયાન હું તેને કોન્ટ્રાક્ટ વિભાગમાં નોકરી માટે આવતી ન હતી, પરંતુ મને માસિક ઉચ્ચક પગાર રૂપિયા 3000 ઇન્ચાર્જ ગોપાલભાઈ રબારી નાયબ મામલતદારનાઓ આપવાનું કહેતા હું મામલતદાર કચેરીએ પુરવઠા વિભાગમાં બેસી ફોટા ફિંગરિંગ લેવાનું કામ કરતી હતી અને મારી સાથે ભૌતિક શાહ સંજયભાઈ ભગોરા બેસતા હતા અને અમારા ઇન્ચાર્જ ગોપાલભાઈ રબારી નાયબ મામલતદારનાઓ હતા અને અમે ત્રણેય જણા કોમ્પ્યુટર ઓપરેટર તરીકે કામ કરતા હતા. જે બંને જણાને મારે તથા રાજુભાઈ ચંદુભાઈ પરમારને પ્રેમ સંબંધ હોય જે હકીકત જાણતા હતા અને રાજુભાઈ ચંદુભાઈ પરમાર મને બોગસ રેશન કાર્ડ કાઢવાની કામગીરી કરવાનું કહેતા મેં ના પાડેલી અને રાજુભાઈ ચંદુભાઈ પરમારે મારા વિવસ્ત ફોટા તેમજ વિડીયો ઉતારેલા હોય મને ફોન કરી તેમની ઓફિસે બોલાવી ગમે તે દિવસ દાડો બોલી મને સોહેનસો કહી ધમકાવી તેમની સાથે રવિવારે તથા નોકરીના ચાલુ દિવસોમાં બોરસદ ડ્રીમ રેસિડેન્ટ ગેસ્ટ હાઉસમાં લઈ જતા અને મને કહેતા કે મેં તારા બીભત્સ ફોટા પાડેલા છે તેનો તથા વિડીયો વાયરલ કરીશ તેમ કહી મને ધમકાવી મારી સાથે મારી મરજી વિરુદ્ધ શરીર સંબંધ બાંધતો હતો, પરંતુ આ હકીકત મેં કોઈને જાણ કરેલી નહીં કારણ કે મને
time and again.
My lord is considered, my lord, the last portion of the FIR. The earlier occasion, my lord, the complainant said that this all the relation is with consent from 2011 to 2015. Now, my
You
lord,
are having some photograph with you and
No, but
you are
this is-
blackmailing the lady who is
the
serving
investigation officer
in your
not found the single documents from the
That's
present
why-
petitioner.
to be tried.
But sir,
tested.
But ultimately, as per my instruction, the charge sheet is not filed. The investigation officer, number of time, my lord, the present petitioner statement was recorded. The complainant is not, my lord, the cooperate, the investigation officer. The complainant after, my lord, the register marriage in 2014, but the complainant remarried, my lord, some other person, and SIB Santi જીવે છે એની life. And she is not cooperate, my lord, the investigation officer. But kindly see, this is the documents that I produced, the investigation
You
officer.
settle outside the court. Why I should interfere in it?
But
There
only
is a
my
gross
request.
case is made out.
પણ સાહેબ નથી એટલા માટે જ મેં સાહેબ આગળનું વાંચવાનું આપ સાહેબને રિક્વેસ્ટ કરી કે if this honorable court permit me, I read the
FIR
earlier
is not
portion of the
required
FIR.
to be read as a whole.
હા સાહેબ આખી જ વાંચવાનું કહું છું એટલા માટે જ હું આગળનો પોર્શન છે this is the crux of the
આટલું
FIR.
sufficient છે. Yes.
Only request to this honorable court, the some earlier portion is required to be considered.
You
Therefore,
can read whatever you want to. How you will get out from this?
yes, my therefore, my lord, the earlier portion, the
ઠીક છે,
she
સર.
said કે ભાઈ સાહેબ 2014-15 ધમકાવી પછી બી હું એની સાથે જતી હતી
Whatever.
મારી મરજીથી જતી હતી એવું કહે છે.
એ તો પછી આગળ આવું કહે છે.
પણ સાહેબ એનું કોઈ proof નથી. The not a single evidence collected by the investigation officer. I visit
the
the number of
necessary-
time police station. As in when the police
76
But sir,
and looking to the gravity of
ultimately, but as per the Supreme Court judgment,
yes,
but
yes, whatever you want to.
if
You can
the
cite it.
if the complainant, my lord, the marriage was performed between the complainant and the present petitioner in 2014. It is a genuine document. The register marriage, say photograph સાથે છે. And in 2018, the complainant
File
said,
appropriate proceeding for quashing of the company. Why?
but therefore I am before this honorable court under 482. This FIR is absolutely bogus. But the complaint, as per the my instruction, sir, as per
Complainant is here.
no, sir, as per the my instruction, the complainant is not cooperate the investigation officer.
Yeah, whatever.
Sir,
It is not your lookout.
no,
It is a lookout of the investigator.
but number of
What do
time
you want? I am not inclined.
that I'm requesting for my the
Please,
right to
it is-
my lord the settle this dispute with the complainant.
You can do whatever you want. but
Very good.
not-
But I'm requesting for 2
no
weeks
process.
time, so at
No, no,
least
time is out of question. You can pursue the remedy. whatever available with you.
Only request to this honorable court, kindly see these documents, मतलब register marriage
Yes, yes.
performed between the parties in 2014.
In so many
And
words,
this
there are material.
and my lord, that this marriage is mentioned in the FIR also.
Irrespective of marriage, then come with her. If she is agreeable to this posting of complaint, then the matter is different. Otherwise, then also I have to examine, right, whether otherwise there is no end. You are misusing your position by
I am
exploiting your subordinate.
છે જ નહીં. એક single documents, if the investigation officer collected the single documents against the present petitioner, સાહેબ હું withdraw કરું. But I visit the number of time the police station and the police authority record the thrice or 5 times, my lord, my
Yes,
statement
yes.
was
What do you
recorded
want?
by the
What
investigation
do you
officer.
want?
So
What
ultimately,
reserve
I am
order?
I fully
Sir,
cooperate the
sir,
investigation officer.
I am not inclined to grant. Presentation is fine for seeking following prayers. The
The only request to this honorable court, I am requesting only the 5 to 6 days. So at least I try to, my lord, because the girl is, my lord, the 27 years.
whatever it may be, ultimately offense
The
is
marriage,
offense.
નહીં, marriage perform
If a-
થયા છે 2014 માં marriage perform થયા,
Suppose
2018
this
માં
was
FIR
happened
file
with,
કરે છે.
40 years old lady, then
2011 થી relation હતા સાહેબ,
What is-
એવું FIR માં લખે છે.
what do you
Ultimately,
want?
the present petitioner is victim, not
What
the
do
girl.
you want? You want
I am requesting for 2 or 3 days, so at least I try to contact the complainant and I settle out this issue.
tried a top of the board.
Very good.
Tried it. Okay.
Number 10, Arsi Jani Associates, Mr. Vinay Dhiman.
Lordship, Mr. Jani is before the another coordinate bench.
Mr. Parimal Singh Parmar.
Plus, essentially, the FIR is under the provisions of IPC 466, 467, 468, as well as certain provisions of essential commodities. Plus, I am accused number 3. The case of the police authorities is this accused number 1, while he was repacking certain urea, that the fertilizers that were meant for agricultural consumption, he was repacking them so that he can in turn sell it to the factory owners for industrial purposes. He then said, when he was asked that who supplied you this material, he said that it was supplied by me. That is how I have been implicated. So the entire controversy revolves around these fertilizers. For this, they have invoked 466, 460. They deal with the record of court and valuable securities. With this background, please see the FIR. Page 2.
Yes.
Page 2, bottom.
Yes.
See, we did
your
the
IO is here.
The posting that no further steps have been taken. Coming to tender the report. This person is subject by
Yes.
Third page. Last 10 lines of work.
Yes.
નંબર 4 ને ત્યાં નોકરી કરતા હોય ખાતરના વેચાણ માટે વિવિધ એન્ટરપ્રાઇઝની લેટર હેડ તથા ટેક્સ ઇન્વોઇસની બુક સાથે તથા સાહેબ નંબર 28 દુકાનેથી થોડી પ્લાસ્ટિકની બેગો ખરીદ કરી પ્રીત યુરિયા 46% ટેકનિકલ ગ્રેડના માર્ક વાળા થેલીઓનું પ્રિન્ટિંગ કરાવેલ તેનું બિલ મળી આવેલ તે થેલીઓમાં ખેતીવાડી ઉત્પાદન સ્વયંસેવકોના આ થેલીઓમાં રિફિલિંગ કરી રિપેકિંગ કરી આરોપી નંબર 4 ને મદદગારી કરી મરી કુલટા સ્વયંસેવકની મસ્તા સાથે રેડ દરમિયાન મળી આવી પકડાઈ જતા આ ખેતી પેદાશના ઉપયોગ માટેના સબસિડી વાળા રાસાયણિક ખાતરનો જથ્થો ગોધરા પોલન બજાર રોડ વાળી ફળિયા નંબર 3 ખાતે રહેતા આરોપી નંબર 3 that is my management line સ્વયંસેવક સરકાર ચેરિટેબલ ટ્રસ્ટના નામે સબસિડી વાળો ખેતીવાડી ઉપયોગી રાસાયણિક ખાતરની ગોધરા ખાને દુકાન ધરાવતો વેપાર કરતો હોય તે ખાતરનો જથ્થો આરોપી નંબર 1 રીઝવાને વેચાણ કરતા આ જથ્થો આરોપી નંબર 2 ટ્રકમાં ડ્રાઈવર તરીકે નોકરી કરતા તેઓ મારફતે સહેજ તેની ટ્રકમાં આ ખાતરનો જથ્થો ભરી વડોદરા ખાતે આરોપી નંબર 4 નીતિન શાહને કબજા કરી તેની નિમિત્ત એન્ટરપ્રાઇઝ નામે સબસિડી વાળું ખાતર ગેરકાયદેસર વેચાણ કરી તથા આરોપી નંબર 5 ના હોય આ ગુનાવાળી જગ્યા ગોડાઉન I'll skip this note. I am having the statement of this person. Obviously, yes, but the material was not from him. He was not caught red-handed because he was the supplier. This might not be a statement.
Yes.
Plus, please see. So the entire controversy revolves around fertilizers. That accused number 1 was found to be repacking that, and he said that I supplied him. Now, for this, they have invoked 466 of IPC. Please see that 466. It reads as forgery of record of court or of a public register, etc. Whoever forges a document or an electronic record purporting to be a record or proceedings or in a court of justice or a register of both baptism, marriage, or burial, or a register kept by a public servant as such, or a certificate or document purporting to be made by a public servant in his official capacity, or an authority to institute or defend a suit, or to take any proceedings therein, or to confess judgment or a power of attorney shall be punished with imprisonment of either description so and so. Thereafter, 467, forgery of a valuable security, will, etc. So whoever forges a document which purports to be a valuable security or a will or an authority to adopt a son, or which purports to give an authority to any person to make or transfer any valuable security, or to receive the principal, interest, or dividends thereon, or to receive or deliver any money, movable property, or valuable security, or any document purporting to be an quittance or report acknowledging the payment of money, or any acquittance or receipt for the delivery of any movable property or valuable security, shall be punished with so and so. Thereafter, 468, whoever commits forgery, intending that the document or electronic record forged shall be used for the purpose of cheating, shall be punished with. So, all this are relating to documents or court or record of the court. I fail to understand as to how they can stretch it to the extent of even fertilizers. At best, presuming everything against me, then also the record is that the person was involved in repacking fertilizers, a commodity which is prescribed under the Essential Commodities Act. But then by no stretch of imagination, they would fall into either of the criteria which are prescribed under these three sections. So by no means this 466, 67 and 68 of the IPC can be pressed into service.
What is Rakha Niyam? Rasayanik Khatar. Why your officers are not recording the entire this provision or name of the act? They read the FIR. Rakhani. What is Rakhan?
In report, he had stated the entire word.
Yes. Prima facie provisions are attracted. I can understand. 467 and 468, you may have a good case. What about other section?
At least other section. To that also, well, let's kindly see how they have simply taken the samples. Please see. there is a prescribed procedure as to in what manner the samples shall be taken. They are to be sent to the authority. They have simply taken five samples out of this. Please see page 4, last 5 lines.
How I can appreciate that,
No,
whether
all-
that procedure is
I understand. There is a decision of
In
Honorable the Punjab and Haryana High Court to this effect that they have to at least mention this particular aspect that they have followed this procedure in the FIR itself. Please,
at the stage of 482.
no, they have to. There is a reference in this journal. Please see the finding of the court, paragraph 8. In this, this was a case of
Depends
trial.
on facts of each case.
At least, knowledge, I would not stretch it to this level, but then at least insofar as the provisions of IPC are concerned, no case is made out, my lord.
You can file appropriate application before the trial court. If you are so confident.
Well, it's on the face of it, my lords. Kindly see, there is no reference to any of the
No,
fertilizers that
is-
is mentioned. And even if we go, ultimately, if they want to include the principle of evidence generis,
Yes, you can approach the trial court whenever the charge sheet is filed. Since you
there was an interim order of the court that the charge sheet may not be filed insofar as the provisions of IPC are concerned.
you do whatever you want.
At least, my lords,
I am
my
not
lords may kindly
inclined to-
consider from the point of view of the provisions of IPC only, not.
Let it be. You can approach the trial court. Yes. What do you think?
I'll not invite these.
Learned Advocate Mr. P.B. Parmar, upon instruction, does not press this petition with a view to avail appropriate remedy. It is clarified that this court has not expressed anything on merits. So everything is.
Great.
You might have a good case for the IPC, but.
But that is the reason I was pressing only to the extent of IPC, not to the provisions of essential components.
Mr. Kishan Daya, Mr. Kishan Prajapati.
Yes, Mr. Daya.
Notice to concern police, it is not served.
Right.
In fact, in case of 406, I am acted as a broker, my lord. The offense of 2014, 18 FR came to be lost. My role is concerned as a broker. Accused number 2, the good came to be sold to accused number 1.
You are?
I'm accused number 2, Guman Singh Parmar. As a broker of that said transaction. As I came to implement.
Transaction of?
Section of 406, 420, 120B and 114 of the IPC. The section not apply.
Sorry, you.
Yes, sir. But they initiate
Why section is not?
40 not attack.
No entrustment?
Yes, sir. Column number 3, the offense came to be committed in the year.
Yes, your IO is here. Call for the report, police report.
Please.
Learned APP may call for the police report. Released on 3rd of August.
Please. I hear it.
Interim relief extended.
Mr. K.V. Pujara, Advocate.
Yes, Mr. Pujari.
Sir, for an incident of a boy and a girl, adult boy and girl falling in love and leaving the village. Now both the families belong to a common ancestor. Therefore, the relations had become strained. In view of that surcharge atmosphere, the house of the father of the boy was, a portion of it was set to fire. And it was considered that the girls' party family has done that. Therefore, the panchas and both the sides assembled, settlement was worked out, and amount was also paid. Now, in that context, complainant says that they had approached the local police station, but the police was not moving. The complainant keeps on writing several letters. Therefore, at page 28, the Chief Judicial Magistrate writes a letter to the police DSP that look into this. That Hawala, your lordships will find in that DSP's letter at 18th February 16, page 28.
Yes.
Chief Judicial Magistrate Dahodna, register number 137 of 16, 15/16. the DSP instructs the police inspector Devgadwaria police station to look into the matter and these applications made by the complainant and his wife and submit a report to the chief judicial magistrate. Now thereupon, the police inspector submits the report at page 15.
Yes.
In this report, the police inspector sets out the incident. He records the statements of several persons and even takes on record the Panchanama, the settlement which was arrived at page 26. And page 27 bears the signature. The first signature is that of the father of the girl, Hansa's father, Kanubhai Patlabai. And after the line, after 4 signatures, the signature is that of the father of the boy, Arvindbhai Mulabai, who is the complainant. The husband and wife both go on writing letters to the courts and to the police officers. Now, even after submission of this report of February 16 to the court, the wife, the mother of the boy, comes to this court by filing an application at page 30 without stating as to what happened before the magistrate, etc., and makes a grievance that though we are approaching the police is not acting in the matter. Therefore, page 31 order is passed by this honorable court referring to Lalita Kumari's case and asking the police officer to look into the matter, and if offence is made out, cognizable offence made out, to register an FIR. At page 34, the honorable court says, refers to the entire history also, and disposes of this application in which we were not even made parties. Nobody is made party. This is on day 1, order is passed. Matter was filed on 1st of April. On 4th of April, this is done. Now, pursuant to this, police may have taken some action because police had already taken that action, which I am showing to your lordships at page 15. After 2 years of this, an advocate prepares a complaint and submits to the court a private complaint at page 36.
Yes.
Against 15 people, including those 3 petitioners before your lordships who are 3 real brothers.
Yes.
2 of them government employees, and therefore it appears that with a view to pressurizing them, because if they are arrested, then suspension will follow. Therefore, these 3 people are involved. Otherwise, totally unconcerned with the boy's family and girl's family, absolutely nothing. Now, history is referred to in paragraph 3 at page 37. Paragraph 2. That both the boy, Bharat, and the girl, Hansa, were adult and they have left, and their whereabouts are not known since March 15. They also refer to that incident of their house being set on fire.
Yes.
About which they have said we had lodged the complaint, but police did nothing, though it is on record as to the police had investigated and submitted report. Then in paragraph 4, he refers to some amount of having been seized from them, 55,000. Now, with regard to this 55,000, which according to the complainant was looted from him, at page 46, the explanation is given by he himself that this amount was used with a view to tracing out that couple. And therefore, there is no question of loot or robbery of 55,000 from me. Thereupon, the police inspector gives an application for deleting that offence at page 46.
Yes.
In which he explains 55,000 રૂપિયા લૂંટી લીધેલાનું તથા 100 લખાવેલ, પરંતુ તે 55,000 રૂપિયા તેના છોકરા ભરત તથા આ કામના આરોપી કનુભાઈ વટલાભાઈ પટેલની છોકરી હંસાની શોધખોળ કરવા માટે વાપરેલ છે, તથા આ કામના ફરિયાદીના મોટા ભાઈ બાબુભાઈ મોળાભાઈએ ફરિયાદીના મરઘા અને બકરા વેચી તેના પૈસા ભરત તથા હંસાની શોધખોળ માટે વાપરેલ હતા, જેથી સદર ફરિયાદમાં લૂંટનો બનાવ બનતો ના હોય. કલમ 394 કમી કરવા વિનંતી છે. And then court passes an order that file appropriate report, etc. But still, in this complaint, so far as these three persons, the petitioners before your lordships are concerned, absolutely no specific allegations of any sort of action against the complainant or his wife or with regard to their property. Absolutely vague complaint after 2 years of the incident, with which also we are not concerned. It's a clear case of abuse of the process of court. And as the lordships would find, complaint is prepared by an advocate stating all sections 143, 147, 148, 149, 394, 342,
The private
52,
yes.
427.
Yes.
Yes,
So-
right. Pursuant to the application at page 45B. This is the application preferred at page 45. Now, it is pursuant there to this application, the court has passed, there is a report filed at page 46. Now, this report which was filed at page 46.
Yes.
There it, the last file is fixed for hearing on 8/3/18.
Yes.
Now then page 47 is unwritten, which is typed at page 47A. The annexure that is the order passed by the learned board. Whereas that is the order with my learned senior field is covering the position. I may just read that. બટાડો કરવાની કોઈ પણ provision ના હોય FIR માં બટાડો કરવાની જોગવાઈમાં તેમજ વધુમાં બટાડો કરવાની કે સંમતિ report ભરવાનો હોય ત્યારથી જ સમય જો report યોગ્ય ફોર્મમાં સુધી આપની અરજી કોઈ હુકમ કરી શકાય નથી. તેમના હાલની અરજી પર Mother, we had already filed our report. What's one which number?
What is your prayer in the present petition?
So far as these three petitioners are concerned, prayer is for quashing the proceedings.
Complaint.
Yes. Complaint is a stock complaint against 15 people.
What is the allegation against you?
Against me, nothing, absolutely nothing.
You are
Number 7, 11 and 12. 3 real brothers.
you are nowhere connected with the
Not
family
at-
of the
Neither the boys family nor the girls family.
Comment number 5 is having. Comment number 5 was filed the application because of donate code below. Is that page 36? The annexure C may handle this.
yes.
You just have to assume that it's not submission, but I'm just. Paragraph 3 is. ROP number 7, paragraph 3 page 37.
Yes.
समय 2015 માર્ચમાં અંદર પગલા કર્યા સાથે હોળીના તહેવાર અગાઉ પતનમાં આવેલા તે સમય આરોપી 7 સૂત્ર પ્રહારના આરોપ નંબર 56
So no substance. Allowed.
Please,
Allowed.
lordship.
One of our choice. Rest of the matter, except for 45. Rest of the matter. One of our choice.
Number 8.
Who is
I think it may be kept on first or third.
first?
First or third, any day.
First,
Perhaps on first, there might be a link, so it is better that.
third.
Or top of the board.
Top of the.
And sign investigation. Over, actually,
Not filed because there is an order.
not to.
Third. Let it be on third.
From 8, so keep
Yes,
See, my lords are inquired with regard to the-
charge sheet.
The next date of hearing. The next date of hearing is on 8/7/2023, which is at the state and evidence of process.
First, I may take the instruction whether the charge is framed or not, my lords. As per my instruction,
Subsequent to the framing of that, and the evidence. of-
Yeah, otherwise also it's ripe for hearing.
may I take
No,
tomorrow,
why-
my lords, top of the board at
No.
11, my lords.
Why unnecessary matters are?
Because I have no instruction to withdraw. That is my difficulty. That is the only request, my lords. Because I,
Tomorrow, top of the.
please, my lords.
Unnecessary, we have to,
Please, my lords, I understand, but my
for
lords, I
your
have,
convenience,
since-
court has to edge on the matter.
since, my lords,
This is
I have no
difficult.
instruction. That is,
At least you should take a instruction. in
my lords,
the
my
matter.
client is, my lords.
And since the morning, I have
my
requesting
lords.
you to look into.
But my lords, the advocate, I have,
Anyway,
please, my lords.
yes, what is the next?
23. Mr. Chetan Pandya. Sorry, I was.
Why this matter was kept by?
This is also GST, we have a-
Yes. GST.
Yes, under the GST. Well, my contention was that I have been.
No interim relief is granted.
No, because subsequently he was released on bail, but the issue of illegal confinement and detention still remains.
Read first order. Criminal miscellaneous applicant 1393 prepared by applicant for releasing the applicant
That is,
on bail is already pending before the.
yeah, I have already now released on bail. my lord.
When
So therefore, there's a.
that similar relief is sought by the present petitioner.
No, it's not
applicant
the,
in
yeah, one of the
representative.
prayer, yes, one of the prayer was definitely here, yeah. There's prayer 10C was for release interim. But
Go
my
and
principal prayer,
face the trial. In
no,
such
trial
a
definitely
special
I'll be
act,
facing, I'm not on
under
the
the
trial.
special act, why I should interfere?
No, yes, I own the limited aspect of illegal detention and illegal confinement. My production was beyond 24 hours in contrary to section 69 of this GST, section 54 of CRPC and article 20 of the Constitution. They were supposed to produce me in 24 hours before the magistrate court, which they did not produce. We challenged that action of non-production within 24 hours before the magistrate court. That magistrate court rejected our application. I am challenging that application before this honorable court. So issue of my illegal confinement still remains, my lord.
Yeah, release the petitioner to issue a written manifest,
Yes,
directing the connection with file number so and so.
that
Register
order
with
where
the-
I have to challenge this.
Thereafter pending admission.
Yes. So, by
So,
pending admission,
what remains now?
pending admission, this has become infectious. But the
Yes.
principal prayer with respect to illegal confinement remains.
Where is that? There is no prayer.
No, it is that my annexure, oh, that is instead of an application. Annexure, oh, my lord.
You can approve the trial court.
No, trial court, I have approved, trial court rejected. That is why I'm challenging trial court's order here. Lots of head on Monday, I'll just make my submissions.
Monday.
Please.
Yes, sir. एक मैटर अजी बाकी है ना? जी, बची કેટલી છે હજી?
Here, my lords, if my learned friend has to take the instruction whether the charge sheet has been
Yes.
filed or not.
I have checked my Leonard Penn's file. There are so many accused. There's under this, investigation going on. His name was there, accused number to the goal is also primarily found. My Leonard Penn also may take instruction what happened thereafter because there are many accused. The offense is not very.
Prime accused was died, my lords. That is why the FIR came to be lodged against this many accused, my lords. In the FIR itself, my lords, it is stated કે બધો વહીવટ ઇન્દ્રજીત સિંહ કરતા હતા. My lord, since he has died, the FIR came to be lodged against the, my lords, 5 persons. I am nowhere connected with this Indrajit Singh. No money has been received in my account, my lord. That is my precise case.
क्या रखा फिर?
Any case, I call the investigation paper. So this case required to be very kind.
Necessary instruction. જવા દો.
Please.
47, Mr. Vaibhav, yes. So this way, Malta.
Yes. Why this matter is kept?
So all the accused except this present petitioner or acquitted lordship. Even the husband is acquitted by.
Yes.
Very good to see the judgment.
But the rest of the accused, sir,
Yes, yes.
copy of judgment is there. Where is question?
Will report to your.
Why?
Day after tomorrow.
Why? For what purpose?
Whether
The same analogy is.
allegations against.
When you have filed the FIR by making same allegation against all the accused.
In one and the
The
same trial.
who are they?
Sorry.
Present petitioners.
Kakaji and Mama.
Husband ne chodi મૂક્યો છે. Husband is acquitted.
Then why Kakaji and Mama?
By કારણ કે pending હતું અહીંયા આપણે there is stay
I'll go through it and we'll.
tomorrow.
Lots.
There's top of
Yeah.
the board. Tomorrow, top of the board. એમાં ક્યાં વાંચવામાં વાર લાગશે તમને?
As is.
Yes,
Serial number 84.
top of the board.
Serial number 84.
એમાં જવશે ને પર કોર્ટમાં જમતી હોય.
May I request my lord the shortest possible date?
80?
84. I'm appealing with Mr. Rao. It's a commercial.
આપી દો ને જુલાઈમાં ઓગસ્ટમાં ના નાખતા લાસ્ટ વીક જુલાઈમાં
28th July.
not possible on that day also
I have
the same
to the
situation
calendar of the honorable. court.
looking to the every day more than
We are the
100 meters.
witness.
Yes.
I have therefore I am only requesting
And
shortest.
practically not possible to take more than 100 meters.
The only difference the trial court is pressurizing, but I would request for one day,
That
and on
day.
that day we may request for the, please.
My lord, serial number 68. My lord's connected matters are coming up tomorrow at serial number 3. Their complaint is under the provisions of Companies Act. So my lord, my request is to keep it tomorrow.
Tomorrow.
Serial number 10721. Look at this matter. Look, my apologies. We were actually very. in the contempt
You are
matter.
you are having many colleagues. One of the colleagues should be here. No. Every time either you seek for adjournment or you,
Yes, yes.
we need some cooperation from your end also.
Sir, I tender my apology. This will not happen here again. The only request is if there are in certain matters, 7 matters, there is interim review. If that can be extended.
Extend.
And fourth, we'll proceed.
Extended. IR extend kar do.
And my apologies,
Yeah, extend.
and